All right, welcome to the planning board meeting, Monday, November 10th. We'll go ahead and get started here. Thanks everybody for coming. We have a number of items on the agenda tonight, about 8 so far. Right now, agenda item number 2 is a continued public hearing for 51 Wadsworth Road subdivision. If you can hear the board, I'd like to actually move that to after the other 2 public hearings. Any objections to that?
Everyone preamble Kingston.
Oh, yes, we need the preamble. You can do that, Steve.
That's how you vote here.
Yes, go ahead. Thank you.
Pursuant to chapter 2 of the Acts of 2023, and as amended as of March 28, 2025, this meeting will be conducted in person and as a courtesy by remote means in accordance with applicable law. Please note that while an option for remote attendance and or participation is being provided as a courtesy to the public and board members, the meeting or hearing will not be suspended or terminated. Technological problems that interrupt the virtual broadcast and is required by law. Members of the public who wish to watch the meeting may do so by using the Zoom login information shown in the agenda. Viewers can visit the localscene.media/Duxbury for information about Duxbury programming, including streaming and watching replays on Duxbury YouTube.
I don't know if you can hear me.
Yes, iPad 61, would you mind muting your connection, please? Thank you. We'll get that figured out. Emily, are you able to? Thank you. All right. All right. As I started to say, I would love to be able to move agenda item number 2 till after the other 2 public hearings. Anybody have an objection?
Madam Chair, I'm sorry, it's not my prerogative, but I do have a 7 o'clock Kingston Planning Board hearing, so I'm just, I don't know how time consuming you expect those other 2 to be, but that would kind of throw a wrench in my
Yep,
name.
to the original. Yep,
Are you
that's
sure?
I appreciate the heads up. Thank you.
Thank you. Yeah, I just don't want to be kind of running out of here on fire.
Yeah, no, that's right, understood. All right, first up, agenda item number 1 is administrative items, the minutes for October 20th. Do we have motions to approve the minutes?
Yes, I would like to make a motion that we approve the minutes of October 20th, 2025.
Any discussion? Sorry, I'll take a second, please.
Second.
Any discussion? Okay, then we'll call for we'll do a roll call vote since Jen is on Zoom today, starting with Jen.
Jen Turcott, aye.
Matthew Ray, aye.
Lawrence Roy, aye. Kristen Rapp, aye.
Wait, no,
Steve Gant, aye.
All right, motion passes. Thank you. Does anybody have anything for the planning board administrative? If they'd like to raise? Okay, go on. So we will continue with public hearing for 51 Wadsworth Road subdivision. So we want to thank the applicant very much for bringing for providing an alternate right of way is the board asked. We appreciate that. Would you like to go ahead and give a discussion on that, and we can talk a little bit about the project as a whole?
I'm happy to set the stage, Madam Chair. Thank you for the record. Rob D'Ambrosio, attorney at law, D'Ambrosio Law, LLC in Plymouth. We've seen us a few times in the 5th planning board hearing by my count. I think, we've, again, to your point, the last time we were here, a few weeks ago, the board asked us to present a so-called no waiver concept plan. That's been done. I think Mr. Brennan is on the Zoom and submitted a letter. He reviewed it, in his peer review capacity, and is seemed to acknowledge that it complied with the town's rules and regs. I don't want to speak for him, but he's got a November 5th letter in the record to that effect. So really coming out of that last meeting, I think the board wanted to see what it would look like with that configuration. We still contend that the original proposal with the 81-foot diameter cul-de-sac is superior for a variety of reasons. I won't rehash them all. So we still ask tonight that the board vote on that plan. And then the only other real significant development from last hearing was we cleaned up the waivers a bit, which was requested. So now the submitted plan clearly delineates the waivers, and I think we've modified some of the language, the rationale. We submitted a memo with a rationale for why those waivers are appropriate. So that's what's before you. And again, we can certainly field any technical questions about the so-called no waiver plan, but I think it was really illustrated to see it's feasible. I'd rather not spend a lot of time going through the engineering ins and outs of it unless the board wants to.
Anything else?
That's all we have for now. Thanks.
Thank you. So does the board have any questions, any thoughts? The application side, this. Questions? And from Jen.
Would it be appropriate, to ask Pat Brennan, what he thought of the plan?
Sure, Pat, do you have anything else that you'd like to add? Or why don't you perhaps give us just an overview, for those who may not have, had a chance to look at the letter?
Sure. So I reviewed the plan, the exhibit that they provided for the no waiver plan. And I believe it does not require waivers. The one thing that I noted in my letter was that the construction of the roadway, which is what obviously the board is authorizing, would not require filing with conservation. However, it's likely that development of the lots, especially lot A, would likely require filing with Conservation Commission, because it looks like, at least with the box that they show for a proposed house, would be within 100 feet of the coastal bank. But again, the road itself, the roadway construction would not require filing with conservation.
Well, I'm struggling a little bit because it appeared, I think, I understand what we're doing correctly. This exhibit is relevant to consideration of the waivers. So I'm not sure if we should discuss this now or in the context.
So I think we've talked quite a bit about the original proposal that currently right now stands with 9 waivers. So I thought we would start now with what's the difference, but by talking about this new alternate right of way. So is there any questions or thoughts? Does that make sense?
I think so, yeah, I think you'd like to consider this as a freestanding point of discussion in preparation to discussing waivers. So, yeah. All right, well, in that respect, I think, I don't know, it still seems like specific to obviously the layout, so to speak. And so I'll just put it right on the table. It's my understanding that the use of waivers in order to render a non-buildable lot buildable is not covered by the law. That's my understanding. So the plan without the waivers has to show the buildable lots. That's what the planning board is doing here. We're endorsing a plan subdividing parcel into 2 buildable lots.
Well, what we're doing is, endorsing a plan or approving a plan that would allow for the development of this property. And we don't actually know exactly where the houses will go, so we don't know exactly. In fact, the houses are built, presumably with the development, their engineer would review this, and he said this is developable as is, and the alternative right of way shows that it could be developed without anywhere.
I don't know. I don't know how to evaluate that.
Yeah, I speak to that point, Madam Chair, briefly.
Sure.
So again, I'm just to try to help explain. You know, it's certainly a buildable lot, right? As a starting point, so I just want to make that clear for the record. We've submitted now a plan that this board asked for last time, which shows what the lot division and roadway layout and infrastructure would look like in the absence of the waiver for the cul-de-sac dimensions. So, and your peer review engineer has said this is a valid plan, just to summarize. We've also, again, months ago submitted the so-called 81-foot diameter waiver plan, cul-de-sac diameter waiver plan. asking to configure the lots differently with a smaller cul-de-sac, which again would also result in two valid lots. Buildability is really neither here nor there, but again, I just don't understand the comment that either plan would be non-buildable or invalid. That to me, it's contrary to everything we've been talking about here. I just don't follow the logic or the point.
My understanding of by endorsing the subdivision plan, you're asking the planning board to assert that this parcel can be subdivided into two house lots. That's what we're being asked to endorse. Is that correct?
We were being asked to approve this plan, yes.
As
Our peer engineer has said yes, in fact, both of them both plans are buildable. They're two different scenarios, one with waivers and one without.
Yeah, I mean, I guess just to add, I mean, as far as I can see. It doesn't seem as though in this case, the waivers are making a non-legal or a non-buildable project buildable. The waivers are certainly maybe, making it easier, maybe cheaper or better or whatever. But it's not as though the waivers are necessary for the project to be sort of achievable at all. Is that fair sort of summary? I think that's.
I mean, that's what this board asks us to demonstrate. Could we develop a 2-lot subdivision on this 4+ acre parcel of land without waivers? And that's the plan that we produced that you've seen. And Pat Brennan said, yes, that's a valid plan that doesn't require any waivers for subdivision approval. So I'm not sure what else we can do here. I mean, again,
the question isn't whether it requires waivers for subdivision. The question is whether it requires waivers for building. Because if it's not buildable, it requires waivers.
If I may, through the chair, to answer your question, the planning board has jurisdiction about whether or not the subdivision complies with the zoning bylaw and the Subdivision Control Act. The building department decides whether or not the lot, after it's released, and if this is approved and the street is built, the building department decides whether or not the building permit can be issued, or if it requires relief from either zoning or conservation. Does that answer your question?
Yes, building inspector makes that determination, I understand that. I'm acting on the principle, my again, understanding of the planning board that this is the last stop. This is where our land use protections are enforced. They go through the bylaws and it talks about minimizing the disruption, especially on places with a slope of more than 15%. All the pointers in here are saying that this parcel needs closer attention. The thing I read in the bylaws and everything that we hear from the applicant is, well, that's not going to matter, or it's not really that bad, or we can go around that. So I'm still feeling like there's a big gap.
if you think,
The law says and what the application says.
So exactly, the applicants provided two different plans for 2 lots, for 2-lot subdivision, and these are all within our zoning bylaw. They've adhered to every single regulation that there is, and offering these two. Did you want to say something, Lynn?
I have a couple of questions.
Please, ask away.
So this alternative, which is the alternate right of way exhibit. I think we're talking about this as a plan that doesn't require any waivers. So are you telling me it doesn't require a section 5.33 waiver for water distribution system?
that's correct.
And you've depicted every 12-inch tree?
I don't know that I would say that, but we haven't asked, we wouldn't need to waive that. We certainly, I mean, are you contending we wouldn't be able to put trees on this plan?
No, I'm contending that our subdivision control law contemplates you're demarcating the 12-inch diameter trees.
So again, I have to say, this seems to me a case of moving the goalposts a bit. because I think it was quite clear to everyone when we were here last time that the board wanted to see if we could do a plan without a waiver for the width of the cul-de-sac.
I'm gonna be candidly sure, that's not my recollection. My recollection was, would you be able to submit a plan that required no waivers? Not just waivers relative to, the right of way, but relative to any, waiver that's sought under the subdivision plan. Under the subdivision rules, and that's what I thought we were gonna get. And if you and I had a different understanding, my understanding was, could you come in here with a plan that required no waivers, at which point, quite frankly, I think we are obligated to approve it.
So I'm sorry, just to jump in, I mean, I think what they submitted, and you guys can correct me if I'm wrong, is sort of a conceptual, it's one sheet, it's sort of a conceptual plan. It's not sort of a full, they didn't submit the full, whatever, 5 or 7 sheets, that would be kind of a full design set. They didn't, I don't think they submitted stormwater calculations. But I think it seems like, at least in the opinion of a peer review engineer, it seems as though it's, I guess I'd say highly probable, I mean, Pat, you can jump in, but sort of highly probable or virtually certain that all of that could follow pretty easily. It does seem like it could be done with no waivers, even though they didn't actually delineate trees on this kind of conceptual plan. Now, I mean, perhaps they shouldn't submit a full set of drawings. But I think this is certainly a helpful exercise to demonstrate what they're trying to demonstrate.
I mean, to submit a 5 to 7 sheet plan set for something that we don't want to build, and again, I don't think anyone in the audience thought was preferable to the other option, and I don't think really anyone on this board thinks is a better design. Again, this was a proof of concept test. Can you lay this out without waivers? And you've got Mr. Brennan's letter that says the layout shown on this alternative plan depicts a subdivision that would not require any waivers from the planning board. So if the assertion now is you didn't show trees on the plan, I mean,
My assertion
That's a
is that
stretch in
this
terms of
plan is
principle.
not, my assertion is this plan is not approvable as it is.
we're not asking you to approve this plan. That's never what, that was never what this board asked for, and
That's
that's
my
not what we're asking.
Yeah, questions about conceptually about this idea, the idea.
I understand what the concept they intended to depict here is. I thought we were trying to come out with whether or not we could do this without waivers. And that we were gonna get a submission package that suggested a plan that didn't require any waivers. If all it is a proof of concept that you could probably do this without any waivers, but this is not what we're being asked to approve. Great, I understand the concept.
And to be honest, I think I was expecting like some plans too. I totally understand why you did it. I get that. And that was obviously miscommunication. That's fine. Yeah, yes.
Paul Rodney, Coast Engineering. When we did the original submittal back in June, we gave you everything you needed for a normal definitive plan. The full drainage calculations, the full roadway profile, everything with the exception of those reasonable waivers that we felt was appropriate for this subdivision. Town officials we had spoken to about public works issues that they felt were not needed for the uniquenesses of this property on Wadsworth Road. And you've already seen everything once. When we walked away from the meeting 5 weeks ago in early October, it was our understanding that we weren't gonna submit a second definitive plan for you people to look at as a concept because it was not needed. And quite frankly, we didn't understand the conversation with that in mind. If you want us to go back to the drawing board and do another set of full drainage calculations in accordance with the mass stormwater regulations and everything else, and just forget about all the conversations we've had with the Public Works Department and other town officials, that's fine, but that's not our intent, and that's not the direction we got from this board 5 weeks ago.
I'm sorry for the misunderstanding. That's right. I think we have what we need. So I don't.
Exactly. So do we.
ruffle any feathers. I'm just saying.
Yeah,
I
so
think-
the spirit
I think-
of
yeah,
the
exactly.
dialogue here, I mean, let's honor the spirit of this dialogue,
Right,
please.
right.
You know, it's really, it's disappointing.
I'm sorry that you're disappointed. I think we were trying to do it without feedback.
All right, so why don't we talk about what's here on this proof of concept here and talk about the fact that the idea, thank you for pointing to, thank you to that. reiterate that, because I know we've been through a lot of different conversations. I think the intention here is we want to look at what does a no waiver plan look like, and so we want to talk as a board. What are any questions or thoughts? Wayne,
If we're gonna discuss the waivers, the subdivision rule requires to do them individual one by one. Don't know if what this means is we're now discussing the waiver that is pursuant, I guess it's 703. Or 7.3.
we just talked about the conceptual plan for just a second,
Why would we do
That's a
that?
good question.
because I think we need to, otherwise we're gonna get this to be a long, a jumbled conversation. I think it's just like, this is what we asked them to do, what's the feedback on this, and then we can talk specifically. I think that makes sense.
All right, I'll give you my feedback. I'm perfectly willing to accept a plan with no waiver. Because you're required. Because Pat says this, they can do this plan. And if they came with a plan, that had all the elements that the subdivision rules require. I would vote to approve it. That's my view. But if we're not talking about that, then I think you have to talk about waivers individually. That's my view.
Steve, any thoughts of this particular
Well-
conceptual plan?
Sure, but I look at the two plans kind of side by side, and just looking at them just conceptually. Yeah. So, from what I can tell here, it looks like the no waiver plan involves a great deal more. Probably use the wrong word, but a lot more exposure along Wadsworth than one that does have waivers. So I think that can have a meaningful aesthetic impact on the neighborhood. If we were to go no waiver and have that much greater exposure along Wadsworth. You get a bit of a trade-off there too, though, because you have you have house A, as you look at it, it's the one on the right, it's set farther back from Wadsworth. So presumably it wouldn't be quite as visible from the street as it would be under the waiver plan. So I don't know exactly what the aesthetic benefit there might be. I would leave that to the neighbors and the butters, what they think. But, just looking at the impact on the neighborhood, those are a couple of the else we're thinking about.
Well, I have a question. And this, I need to go back into waiver land, but, now that we have it, it's able to review them and compare it to the language and think about it individually. And I picked up on something that I'd like to just verify. According in the roadway design, 538. But the regulations say that the perimeter plan to show the extent of cut or fill limits outside of the road layout required for construction of the way. Maximum 2-to-1 slope unless waived by the planning board due to a topographical hardship. So as I read this, look at the plan. The retaining wall is greater than maximum 2-to-1 slope, so I think the retaining wall itself would require a waiver of topological hardship. As I read,
I think this is for the conceptual plan.
either one, it's in both. Was that correct?
I wouldn't have thought the retaining wall was a slope.
Well, that's the whole point, is that it would have been a slope that was more than 2-to-1, so it was eliminated by installing a retaining wall. There's no retaining wall there now, so that's the improvement, so that's the proposal. But that's why I'm asking, I don't know whether this is.
Yeah, I mean, I'm not to say that we couldn't do a on slope, rip wrap or something like that, but.
Yeah.
I mean, if it is. Again, it's asked for the waiver, so I mean.
Yeah, that's what I mean, it's a big wire waiver, and I just like.
Pat, would you be able to weigh in on that? Did you understand Tag's question?
Yeah, I've never seen a waiver requested for a retaining wall. But I'm trying to look through the rules and regs now to see what it says about it. So if you just give me a couple minutes, I'll take a look and get back to you.
Anything else, Tag?
Nothing specific, and that is what I generally.
Thanks. Matt, any thoughts?
No, I mean, my recollection from the last meeting is we had requested the applicant to clean up
finalize the requested waivers, which they've done. And to give this concept plan with the 150-foot diameter plan for analysis purposes, vis-a-vis compared to the plan, what they're looking for, which I think they've done, and I think we're probably in a position to review the waivers. I don't know that it makes a lot of sense to spend a lot of time going through the concept plan. Because, the applicant said they don't want to build a concept plan, and our request was do this plan so that we can compare vis-a-vis what the 80-foot diameter compares to the 150-foot. Which I think they did.
Do you have any thoughts on the design conceptually or?
No, I think conceptually, I think the better plan is 80 feet. But as we know, the threshold for waivers is the best, what's in the best interest of the public. If you're staying with the intent of the bylaws, right? Well, we're talking about 2 lots subdivision here.
Yeah,
The public interest is 98% of the people that live in town are not going to be affected by this.
right.
It's really the abutters that are in the back crowd, so I'd like their opinion where they think the 80 foot vis-a-vis the 150. And when we were here, I think, 5 weeks ago, I think a lot of the crowd said, oh, we want the 150 foot because now it pushes the project into the Concom and now that, that. Well, that's a double-edged sword, because there's a high likelihood that if they do have to file the Concom, it still would get approved with conditions. And now you've got a bigger 150-foot diameter driveway. I think, aesthetically pleasing, I think the 80-foot is the better. But obviously that requires a waiver, subject to the board. If we don't want to grant a waiver, then we're at 150 foot. And I think, Steve had just mentioned, it has more of an effect, environment.
I like to hear from the abutters. I feel the same way. Aesthetically, this is more detrimental to the neighborhood, so I'd really like to hear from the abutters.
Right, same, thanks. Let me check in with Jen. Jen, any thoughts?
I agree with what, I didn't mean to interrupt, Matt, but I do agree with what you said about, okay, we have the conceptual plan now, it's what we asked for. What we really need to focus on is the list of waivers and whether or not the board's willingness to grant any one of them.
Thank you. I like Matt and Lauren feel that like the approach of the original plan because of this smaller cul-de-sac, because of the smaller right of way. I do think that it would be more in keeping and more harmonious to the neighborhood to have the other houses that are more in parallel with the street. With a smaller or potentially a smaller solid surface as well for the driveway, but we would like to hear from the abutters, so I believe we have some in the back row. Would anybody like to share with us your thoughts? Have you had a chance to see this conceptual plan?
Yeah, Mike Callen, Arrowhead Road, here representing myself. I guess my gut reaction after seeing the plan with no waiver was bit in awe how a cul-de-sac can be shaped like a half moon. Still we consider it cul-de-sac, but it looks like there's no formal definition that a cul-de-sac has to be more than 180 degrees to meet that 150 feet diameter. It's just something I'm not familiar with seeing very often, so that was a little bit of a surprise. And I guess the square footage for the lot on the right side, meeting the 40,000 square feet by 167 square feet, we're showing 40,167 square feet on that lot. Back to my first letter, back to my second, back to my third, back to my fourth letter.
I
The
appreciate
coastal
that.
bank still affects that.
Hold on, just, we've
Can I finish?
talked about,
Let me
no,
finish, please.
no, actually, no, we've talked about this quite a bit, Mike. Our question is simply, what's the preference of the neighbors? Would you rather see a smaller footprint? Would you rather see a smaller cul-de-sac, an 80-foot wide cul-de-sac, or 160 feet? That's really that's the question, because we've addressed everything else. And it will be the building inspector will take care of measuring the lot size. We don't have to worry about that here. So any thoughts, any preference on the two designs for the conceptual designs?
I prefer to see one house be built there.
Got that? Appreciate that.
Please.
Really noted. Yes, sir.
Rick Washburn, 50 Wadsworth. I prefer one house.
Okay, on this, do you have any feedback about these two? Because we'll be voting on one or the other.
Actually, it seems to me that by making the cul-de-sac only 80 feet because of the fact that, it has the houses closer to the street, is kind of a problem because it's supposed to be 150, is it not? Which means that it really probably screws everything up. As far as bringing fill in, slopes, the cul-de-sac itself, the slope of the cul-de-sac, the whole thing. It makes it easier for them if you make it 80 feet.
Any other thoughts from any of the other neighbors?
Yeah, Andrew Burns, 80 Wadsworth Road. You know, it's kind of coming prepared to talk about some different things, after hearing your last comment, obviously, won't get into the coastal bank. I mean, my preference, and I think anybody that really looks at this would determine that a single unit house is really all that can be put there. To do anything above and beyond that just doesn't make sense. But I do have a question insofar as why the Conservation Commission has not yet been involved. Mr. Heim, would you be able to help me with that?
Well, that's not the question the chair of the board is asking.
Is there a chance to get that question addressed? Because it's my understanding that the local conservation commission has direct oversight and jurisdiction over the coastal. So we're talking about.
We're not going to talk about the coastal
Okay.
area. That's not in our purview today. We're simply looking at two different plans and when we get some feedback from the neighbors.
But if we don't have them involved at this stage when we're planning,
We don't.
what
have
is
to-
gonna happen?
I'm sorry, please, we're not going to talk about that. We've talked about it before. We've addressed that already. We're not going to talk, that's not within our purview.
it's not,
It is not.
it's
within our
not,
purview.
because. When
So I'm
you're
sorry,
looking at the description,
I'm going to stop you. We've talked about this quite a bit. We have other things. We have to move on. with
I just wanted to know if you would liaise with other commissions within town. And I thought this would have already happened. So if that's the case, I understand.
Are there any other neighbors who would like to weigh in on these two different proposals?
Andy Hargrave.
Yes, sir.
22 Arrowhead, we prefer one house in that.
This is the third time I've heard that and I
I know,
appreciate that.
I'm just chiming in, I understand.
Okay.
Yeah.
So we're giving you an opportunity to weigh in on a two lot subdivision.
Yeah, and I'm just curious, how many waivers are allowed in any scenario?
Yeah,
If you're on Washington Street or Surplus or anywhere, you might go in Duxbury. It seems to me it might be a little more difficult to cram in two structures in one of those neighborhoods rather than our small area.
So it's a good question about the waivers. We've actually talked about that amongst ourselves. We've talked about publicly and I've talked with the director of planning about that. And it's really about, it's not so much a number, it's really about maybe the quality and what's the maybe the best, not maybe, what is the best use of that property?
And
What's
that's why
within,
we're here, yeah.
and what's within, what makes the most sense for a particular lot, a particular project.
That's exactly why we're here. Thank you.
Right, any other neighbors? Thank you. Any questions? All right, so we've conceptually looked at this. Zach, did you want to ask any questions? Conceptually? Okay, so we've seen this. This is a possibility now. Do you want me to go back to the original plan? Talk about waivers?
Yes.
You think that's hot? Okay. All right, so if we look on page C2, all the waivers are listed there as well. Like the letter things from them. I'm going to go through one by one and look at the waivers. All right, so the first one is the
I'm sorry, would it be more productive to discuss to discuss all the waivers, but maybe to go first with the 80-foot versus 150-foot diameter waiver, since that's kind of such a crucial one for the whole design, to discuss that one first. Might be helpful. That is kind of the big one.
it's kind of sort of the temperature of the board.
Yeah.
Thoughts
It's up-
generally speaking
It's up to you,
about
but I think that might be,
80 versus
yeah.
2.
I'm inclined to grant that one myself. I'm in favor of the 8-foot cul-de-sac.
But that's number 7.
That's number 7.
So resuming with, so
Well, actually, let's go one by one. I think it'd be better just right on the list.
Yeah, if I can send this something.
Please.
To parse through this, it seems like 4, 5, and 6 relate to the section 5.4 as built. Plan requirements, section 5.5, roadway acceptance plan, and section 6.4 as built roadway acceptance for security. These are all related to fundamentally the question of whether the road will be accepted by the town, as I understand it. Since we don't plan for that, we don't think that these are necessary. Then I noted that in our regulations, it ties into the shade tree also. Section 11. In section 11, it says the developer is responsible for maintaining the health of trees for 2 full growing seasons, or until such time as the as-built plans of the street are approved by the board, private ways, or acceptance of the street by town meeting public ways, whichever is the. So this part, the shade tree part of the regulations say that the developer is responsible for the trees until either the as-built plan is approved or the town accepts the way. So these 4 waivers are all kind of intertwined. You know, if we grant the shade tree waiver, then we need something for approving the as-built plan. Or else the developer is stuck maintaining the street. You know, so I have some concerns about the relief of either form of accountability for completion of the work. We have another case where a developer, implemented a 3-house subdivision, never finished the driveway. There was security in that case, and even then it wasn't enough to make sure the work got done. So not having any surety in there at all makes me a little bit. The simplicity of the job notwithstanding. So I don't know if that gives us an entry point into maybe some of the easier ones to deal with the shade trees in the roadway and get them disposed of before we,
Why are we talking about?
All right. Well, so as far as the water distribution system goes, and all the other things we've seen, we put them on the plan. It says it should be on the plan, it's not on the plan. I think that I just need to put the water lines on.
So did you read, may I interject? Did you have a chance to read our memo explaining the rationale for each of these waivers?
Oh, I understand the rationale, I'm just commenting on the material in front of me.
Well, then maybe for the benefit of the audience and the board, I should briefly explain why we want each waiver, because
Hold on.
in a vacuum, these,
Hold on. It's okay. Do you, let's just, I appreciate you, but hold on a second. So if we go, let's go one by one. Section 5.3, the first waiver is for section 5.3.3 water distribution system, and they're requesting a waiver. Because Mark Cloud, our water and sewer superintendent, said that it's not needed.
Yeah, well, I agree. I mean, it's design doesn't require water meeting, that's fine. I'm just saying, in that part of the bylaws says draw it.
but that's what a waiver is. We're saying, why should we show on the plan if the superintendent doesn't want water service to be ran that way? What would be the point of that? Why wouldn't you?
The
grant that
waiver that we granted on the last one had the drawing to show where the lines were.
That's all come onto the plan. I really do.
That's a little different. I think.
Don't worry about it.
Jack, come on.
Heck, this is frightening.
What was the last one? I'm sorry, through Chair, Madam Chair, Paul Brogdon, Seacoast Engineering.
He's talking
Jack,
about.
if you could just give us the last project.
Mr. Warner, he's talking about the one in surplus. It was a cul-de-sac and they would set up, it's supposed to be.
Did it have a water main going up?
There was one version with a water. main.
Exactly, we don't need
Without.
one on this project. This is different from that, it's different from Glenway across the street from
I
here.
just said it. The waiver-
They had 8-inch mains, we don't need one
He said the
here.
waiver's fine.
Thank you.
Okay. All right, any thoughts on that particular waiver? I think maybe we'll do one by one, I'll ask everybody. See,
I'm fine with table 1.
I would vote against the grading.
I'm in favor of number one.
In favor of one.
In favor.
Jen?
In favor of 1.
All right, let's go to number 2, section 5.3.8, plan profiling cross sections. The applicant requests a waiver of the requirements to provide a plan profiling cross section for the subdivision. The street is an actual, I'm just gonna go ahead and read this out loud so everybody's, we're all in agreement. It's an actually a modest driveway that will serve no more than 2 potential dwellings and will extend only 100 feet to right of way. Moreover, the roadway will remain private under a homeowner's agreement, and the applicant does not seek acceptance of the roadway as a public way, so the exact specifications of the roadway are not of public interest. complete plan and profile would be excessive for this small driveway. Kind of tying into the roadway acceptance. Any questions there? Yeah, applicant, see,
Yeah, I guess, you're requesting a waiver of the entirety of this particular requirement.
Yes, of illustrating the roadway in detail, yes.
Okay. So section 5.3.8, I mean, has a number of different components to it. I guess I was just looking for a little bit more detail as to, why you're thinking each of the components of 5.3.8 would be unnecessary.
So 5.3.8 says that a plan. That you should provide a plan, a profile, and a cross-section for a roadway, right? We're suggesting that none of that is necessary in this case. Because there is such limited public interest for a 100-foot long driveway that we will agree not to ever seek public acceptance of. So we think all of it is not germane to this project.
so I think, as I understand, the applicant's looking at this as a shared driveway as opposed to a new road.
Correct.
To boil it down.
Yeah, we're seeking a waiver of this requirement to illustrate the roadway construction details.
Essentially.
In defense of the request for the waiver itself, keep in mind, when we do a normal subdivision, whether it's 4 lots, 5 lots, 10 lots, you basically clear cut everything within the 50-foot right of way. You're gonna have the roadway width, you're gonna have the Cape Cod berms, you may have a sidewalk unless that's waived. But more importantly, you need extra space for the water line, the gas line, and all the underground utilities that are required by this community and the planning board rules and regulations. In this project here, because of the uniqueness of the existing frontage that we have in our conversations with the Public Works Department, the individual utilities can come in directly from Wadsworth without going through the right of way. So that obviously allows us the flexibility to basically cut only what we need for the common drive coming in for the 2 lots, the hammerhead at the end, and then the catch basin and the stormwater infiltration system at the end. And I don't know the catch basins, it's just the catch basin at the end, so there's no stormwater piping coming in from Wadsworth Road at all. Everything is sloped towards the back to meet all the stormwater regulations, so the only thing you're gonna see within the right of way is basically the common driveway going in with the hammerhead and each individual driveway, one to the left and one to the right respectively. So it minimizes that sort of work, which obviously has that compounding effect on the need for the roadway profile and also the next item on the environmental impact assessment for mitigation, because we're only clearing what we need for the driveways, period. And it works.
Answer your question.
Yes, thank you.
Okay. Well,
This is the one where I was wondering about the. Do one kitchen routine. So.
on the plan proposed cross section.
Yeah, because that's where the regulations and bylaws require that the applicants provide the information necessary in order to understand the impact on the land. And that information, as I understand it, feeds into some of the other analysis. And so we've got this kind of as I pointed out with the other ones, one way builds on another.
So, Tony, what are your thoughts? Yeah.
Well, it's because of the, it's a short road, yes, no utilities, yes, but because of the bill and the infrastructure, guardrails, I think it has built support. Utility per se, but it is infrastructure. So my view on waivers in general really goes back to what I perceived was a real disconnect between the zoning bylaw with respect to what a house lot needs to be and our subdivision rules with respect to a particular small house. Or small subdivisions. And we set forth in our subdivision rules, specific rules for subdivisions of land that creates 3 lots less. And this applicant has come in and said that they can build this subdivision without a single waiver. We have to make a finding that these waivers
are consistent with the intent and purpose of both the subdivision rules and the subdivision control law, and that these are each in the public interest. I can understand the private interest in all of these waivers, because it's gonna make it easier for this project to get developed, because it's gonna make it less costly to get developed, because it's gonna be something that would be very much something that the private actor would like to avoid. But I don't understand how we can get to any conclusion in which we conclude that any of these waivers are in the public interest when the applicant came in and said they don't need any. So I'm,
Lauren? Or third waiver.
Yeah.
She knows
Wait,
it's
that's
the
the second one.
We're on the second one, right?
Second.
second one,
Yeah.
yep, sorry.
At a loss for words now. Given the waivers, I think I would be for this one, if we stick with this one, depending on the cul-de-sac ruling.
This particular waiver has no bearing on how the project is developed. It's strictly a cost or savings. I'm not inclined to give this one, so I don't see that the cost savings is in the public interest. But however we decide yay or nay on this particular, will have no bearing on the actual overall development of the project.
Jen?
I am not inclined to grant waiver request number 2.
Not inclined?
Not inclined.
Thank you. Okay, thank you.
One question, would the retaining wall be considered infrastructure?
Pat?
Yes, the retaining wall is part of the roadway construction.
So it's part of the infrastructure then?
Correct.
So is it necessary to request a waiver for the construction of the retaining wall? If I may.
I didn't see anything that required, there's really nothing in the regulations about retaining walls. I did a search through them, there's nothing in there. I've seen retaining walls on several other subdivisions. In some other towns' regulations, they do have requirements on retaining walls, but there's nothing in the Duxbury regulations. So this, I've seen them on other projects and they haven't required waivers.
Thank you.
Thanks, Pat. All right, we'll go to number 3. That's section 5.3.9, environmental impact assessment and mitigation measures.
I'm sorry, are we voting on these? Or have we voted on these? How is this working? We're just discussing.
We're discussing. So section, is there saying the environmental impact assessment and mitigation measures, the applicant requests a waiver of the requirement to provide an environmental impact assessment. Given the very modest scope of this 2-lot subdivision, this small paved driveway area that will result in minimal clearing and all site work occurring outside the 100 buffer zone to the wetlands, there will be negligible impact, environmental impact, including minimal impact to groundwater resources, water bodies, and water supplies. Further, the site is not located in the Aquifer Protection Overlay District or APOD. Jen, what are your thoughts on this one?
Sorry, I'm toggling between the Safari to look at the plans and the Zoom call. Because the roadway construction is outside the buffer zone of any of the resource areas, I am inclined to be in favor of granting this waiver, because I think that any filing for the construction of like the house would be within the buffer zone, and conservation would be able to address that.
James. Matt?
Yeah, I'm torn on this one. I agree with Paul and the reasoning here in Seacoast. It's a very minimal driveway. The disturbances are extremely light and to echo what Jen says, it's well outside of the resource area in the Concom jurisdiction and not nowhere close to environmental sensitivity. However, the legal threshold is is it in the public interest to grant this waiver? I don't know that it's in the public interest to grant and, you know, waive the implied environmental impact assessment, mitigation study or report. Practical sense is it really necessary? I don't know that it is, given the small size. Is the test for the threshold of the waiver, is it in the best public interest? I don't see how it is. So we grant the waiver on this one.
Madam Chair, may I make a 30-second remark just about public interest? Again, I understand and appreciate the literal reading of the rationale for granting a waiver, and I appreciate it. I do think, though, that this board should be cognizant, if they're not, of the practical nature of waivers under subdivision control. They're routinely granted for practical realities and efficiency. And I think that Mr. Brennan, or maybe a professional engineer like Ms. Turcott, would affirm that. For instance, and again, then I'll stop. There's really no way, I don't think, to justify a public interest in replacing 18-inch granite berms with 12-inch Cape Cod berms. There really isn't, but the reality is that's a waiver that's granted. I would wager every single subdivision that's been before this planning board in the last 15 years, because it's not necessary, and on the ground, there's no benefit to having an 18-inch concrete granite berm. You know, so again, I just want to make that point that waivers are granted when it's unnecessary from a practical standpoint to require that condition. Like this one, where you're well outside of the conservation jurisdiction, well outside of any sensitive environmental area, you're not in a natural heritage or APOD area. Why would you do an environmental impact study? It is trying to save cost, I'm not going to deny that, but you know, we're trying to be somewhat practical, and I think the board does have an interest to treat an applicant fairly and make a decision on what's practical, not just be a slave to the words of the bylaw and try to hold everyone's feet to the fire to the maximum extent. I don't think that's the planning board's prerogative. I just wanted to make that statement. That applies to all of these waivers. Thank you.
Lauren?
I would not grant this waiver, I would not be in favor of it.
I agree with Jen on this one. Wayne?
I don't believe that there's a public interest that supports the waiver of this analysis. I know that the public has reflected in these various hearings. No real concern about water bodies, about existing water supplies, about cumulative impacts and the degradation of the surrounding area, all of which are served by this particular subdivision rule, and I would not waive it.
Thank you, Chair. In terms of addressing both, you know, the attorney's comments and this particular requirement, it's certainly true that as citizen board members, you know, we're here to interpret the law, and we understand that waivers are granted on a regular basis for matters which are de rigueur, so to speak. The leach berm is a classic example. Piece of regulation just hasn't been updated. Really should be. We all know it. Nobody's quibbling about that. The issue with this application specifically is that we're in an extended negotiation. I mean, you guys came in January with one approach to this project. We said, well, that's probably not a good approach, and we took that into consideration. We've been having these constructive conversations at every turn. So I really appreciate that. I know it's painful, somebody who's got a project that they want to move forward, to go through all this chapter and verse, but it's very important because these are our bylaws and we are the body that's tasked with enforcing them. So I'm perfectly willing to grant leeway where leeway is appropriate, but if that's the rule, the applicant gets his way, then we're not doing our job. I'm just trying to Okay, it's nothing personal. In terms of the environmental impact assessment, according to the regulations, I'm new to this, so I'm going by the book. If things are done another way, you'll have to correct me. The regulations require that a request for an environmental impact waiver be provided with the preliminary plan. And then at that point, planning board would decide if a waiver was appropriate, and if so, material would come in with the definitive plan. Since there was no preliminary plan, I don't see how the planning board can procedurally grant this waiver. Further, the bylaws say that we require an EIA to minimize the impact of areas with steep slopes, floodplains, wetland resource areas, unique landforms, and rare or endangered plant and wildlife species. And this parcel has all of those things on it. So there are intrinsic reasons why an environmental assessment is important. Finally, regulations also state impact to surface water bodies within the bay and whether the possible impacts are limited only to the subdivision or contribute to the cumulative incremental impact of environmental degradation of the surrounding area. And we have heard from residents all around the ravine. We know that removal of vegetation and development of the slope, further down the slope you go, the more widespread that impact is. So these are just the facts of belief. So for these reasons, I think we can't support the exception for the.
I picked up also on the preliminary plan submission, timeline for requesting the waiver. And then I concurred also with the, you know, with the impacts, you know, going right to the text of the regulation. Minimize impacts to steep slopes, floodplains, wetland resource areas, all of that. And it goes on, things additional that are here, impact existing water supplies. Community services such as fire, police, public works, impacts of erosion from roadway, drainage, or regrading of land for house site construction. All of these are part of the regulation. I do not think it's in the public interest to waive this particular part of it. So I would be opposed to this particular waiver.
I think on that one, there's a clear no. All right, we'll move on to the next one, which is section 5.4 as-built plan requirements. As noted in waiver request number 1 above, there's no on-site water distribution system. The remaining proposed utilities are de minimis, particularly given the short and modest driveway and the fact that no more than 2 potential dwellings will be served by the utilities. The applicant therefore requests a waiver of the requirement to submit a utility as-built plan. We can start with you.
Oh, I'm sorry. If I could just jump in again, I think, to me, this is definitely a waiver that should not be granted. I mean, I think, the as-built plan, I think for the next one, maybe you can waive that one, roadway acceptance, but as far as the as-built plan, I think that should definitely be required.
That was exactly my point here, Matt, is that, you know, an accurate as-built drawing of the development should be submitted to the board for approval within 90 days of completion of all construction. We cannot waive that. We absolutely must, we should not waive that at all.
Okay. I agree with you. I think, I understand it is not a very extensive. It is de minimis. However, there are times as a homeowner, I would like to be able to go back to a planning board and see actually where things went when I built it in the house. So I agree. Lauren?
Agreed. I think if we were talking strictly the utility as-built plan, then we could grant the waiver because the utilities are covered in on the street.
Yeah.
But in this particular situation, this particular section is not just solely restricted to a utility aspect.
Jen?
Agree, we should not waive this. There's no way for the planning board to agree to lot release because the criteria for lot release is that the project was developed in substantial compliance with the approved plan. Without an as-built, we don't know.
Also, if I could jump in, I mean, I don't think we know for sure that the utilities are gonna come in from the street. It's probably, obviously, that's what the applicants are hoping, but it's possible. I mean, this is outside my expertise, but it's possible they may wind up coming in through the cul-de-sac anyway, so just to mention that.
All right, next up, section number 5, section 5.5 roadway acceptance plan. This section only applies to subdivision roadways intended to be public ways accepted by annual town meeting. As the proposed driveway will remain private in perpetuity, a roadway acceptance plan is inapplicable and the applicant requests a waiver thereof. Jen, we'll start with you.
So part of this is the roadway acceptance plan security is the bond, right?
That's 6.
6 is, section 6.4 is the as-built roadway acceptance plan security, right?
Yeah, but we're on number 5.
We're on number 5 though, Jen.
I know, my question is this the requirement to post a bond?
We're not on.
No, I think this is just.
Roadways intended to be public ways, a separate road acceptance plan shall be submitted.
Right, but since they don't plan to ever ask for it to be public, they don't need to make a road, they're asking not to have to make a roadway plan because they don't plan to make it an acceptable plan.
Yeah,
Okay.
what was confusing me is security. Which is, the request that they're asking for includes the word security. If it's,
Let's take a look at the next section.
That's the next one.
6.4 has a bond amount calculation.
So 5.5 is just the plan and 6.5, 6.4 includes the security and the bond calculation.
right, so I am not inclined to grant this waiver request, 6.4.
Okay. How about 5.5?
I'm also not inclined to grant 5.5. I thought we covered that already.
Okay, thanks, Jen. Matt?
I'm inclined to grant this one as the road's not gonna be accepted, so I think the provision of the bylaws, they're not applicable.
I agree. I agree on this one. Wayne?
My only question is, how do we ensure that this roadway is not offered to town for acceptance by the town? Is there a device that we use for that? Because I agree, if it's never gonna be offered, then I don't think 5.5 applies.
Well, a good question. We've asked the same thing. So we started doing in the, anyway, what is it, the covenant?
I think it's a decision,
And the
it just
decision,
says that like this is not intended to be a public plan.
yeah, so it's actually, it's in the minutes, it's in the decision, so that if anything ever, 30 years later, the owners wanted to come back to town, they would come to the planning board, we'd have to make a recommendation, we'd go back, look at our minutes and say, no, the planning board that time.
Well, I'd rather see the decision.
Yeah, it needs to be in both, yeah.
Yeah, then if that's the way we're gonna handle it, then I don't 5.5 applies.
Okay,
Yeah, we can accept this plan.
I'd be in favor of this program.
thank you. All right, section 6.4, so this is the as-built and roadway acceptance plan security. This section only applies to subdivision roadways intended to be public ways accepted by annual town meeting for the same reason specified in waiver request number 5, which we discussed. The regulation is inapplicable and the applicant requests a waiver thereof. So I start with you.
Yeah, so I guess I'm inclined to not accept this particular waiver. The section calls for security and to ensure the completion of an as-built drawing of the development, and I don't think that we can raise security for that particular requirement. So for that,
Yeah, as noted before, it's part of the infrastructure, I think you gotta keep.
Wayne?
I'm gonna get posted later.
Same. Lauren? Same.
Agree.
And Jen?
Same, I'm not inclined to grant this waiver request.
Thank you. And then Jen, we'll start again with you on section 7.3.10C. That one, local street 80, and this is the big one, 80-foot diameter cul-de-sac. The applicant requests an 80-foot diameter cul-de-sac instead of a 100-foot diameter cul-de-sac. With the minimal additional frontage needed to create this 2-lot subdivision, the 80-foot cul-de-sac meets or exceeds all driveway layout requirements and adequately supports emergency vehicle and equipment access for the town of Duxbury. In addition, an 80-foot cul-de-sac will allow the clearing of a much smaller area and preserve the natural state of land as much as possible. The neighbors appear to favor a smaller cul-de-sac with less clearing and disturbance, and 80-foot cul-de-sacs have been approved by the planning board and other small subdivisions. All right, so Jen, we'll start with you.
I am not inclined to grant this waiver request.
So you would prefer to see the 150-foot conceptual plan instead?
Yes.
Matt?
I am inclined to grant this, given some of the comments from the abutters. That they would prefer a smaller roundabout, less impact clearing. So for those reasons, I do think it's in the public interest, because public interest are in the abutters. So I would be in favor of granting this particular waiver.
I have a couple of questions first. Is this a paper cul-de-sac or is this a full cleared paved cul-de-sac?
Would you like to answer that?
Yeah, so I think we sure, happy to answer that. We presented a concept plan at the last couple of hearings showing kind of that T. So that's the extent of clearing roughly.
Okay, for both of them, whether it's the 150 or the 80?
Correct. The intent is to keep as much foliage as possible.
Yeah.
That's what I'll be-
So it's, so the paved looks like it's just about the same, whether it's 150 or 80.
You're going to the, sorry.
I think it would be more like,
Well, I guess we connect the houses, yeah.
yeah, you connect the houses with the driveways. Is that
That's
fair?
exactly what I was gonna say, is that most of the clearing is gonna come down the houses, because they all be pushed back.
Just a statement, I guess, not really relevant, but I'm kind of disheartened that we can't go to what the butters are asking us to, and not one house, but two houses without the cul-de-sac. I'd like to see two driveways here. Because of that, I would not be inclined to approve that one.
I do think looking, I would actually be in favor of this waiver, and the reason is, I believe that it would be a more cohesive look. Ideally, as I've said before, I wish that there was 400 feet of frontage and we could have two houses, but we don't. I do wish that our bylaws didn't tell us that we had to do this, because I think we have some opportunity to do something else, I think, but because of the frontage requirement, we must have 200 feet, so we're creating that with an 80, I think the 80-foot would be sufficient, and I think that would be more harmonious with the neighborhood, so that would be my vote. Right?
7.3.10. One provision of this subdivision rule that explicitly sets forth special rules for these small 3 or less lot subdivisions. And it sets forth a relatively small number of special rules. I don't see any reason that they should be waived. It appears to me that they were specially intended to deal with small subdivisions. And we're waiving it out of convenience. But it doesn't make sense to me that we have a special provision for small subdivisions. It has a modest number of special design standards, and the principal one we're going to throw away. That's a hard no.
Okay.
Well, part of what I'm struggling with here is that it's sort of this predicate. Predicate is, it's going to be subdivided, it can be subdivided, it shall be subdivided, which subdivision would you prefer? And that to me is the cart before the horse, we're supposed to be deciding on the subdivision. And again, I know we have this disagreement now about what the planning board asked for last time. It was also my understanding that we would see a plan that doesn't require waivers. And I don't mean to, in any way, go against Mr. Brennan's advice. I just think it's unfair for us to place the entire onus of the planning board in determining whether a plan, is complete without waivers. On him and whatever limited time he has to review these. But we clearly didn't receive a plan that doesn't require waivers, so I still don't know. what the actual waiver-free subdivision
So question, I don't, elaborate, can you elaborate there, Tag, because I don't understand. This is a conceptual drawing. You took out all the waivers, you removed all the waivers. Maybe we need to talk about trees, so that's something that, but.
Well, that's the thing, we started with a mucking list of waivers that we couldn't pin down until we got these drawings. And we got a plan that is purported to be without waivers, but assumes that many of those other waivers are granted, so it doesn't. You know, I'm a logical person, I'm trying to be logically consistent and complete here, and it just doesn't seem like we have that
You
information.
don't feel like you have enough information on a conceptual plan, it's too conceptual.
So if you saw the granite curbs, that would help you visualize, or if you saw the water distribution system that wasn't gonna be built, I mean, that's.
It's just a plan without waivers, that's all we ask for.
Yeah.
I know, it's a convenience thing, it's an excess cost, I agree with you.
No,
guys.
the illustration.
We're helping us to kind of keep going forward.
Yeah.
That can answer the question.
Sure, yeah, as I mentioned earlier, I'm inclined to approve this particular waiver, for reasons, Madam Chair, that you would say it does appear to have less of an impact on the neighborhood, and to me, that's a critically important aspect of this, if we're choosing between the two.
I just really do, I've been trying to keep notes of who was in favor of that one, it was Steve, me.
No.
Yeah. Okay, so that one was 3-4. All right, and then let's talk about the last one, the low, sorry, 2 more to go. Section 7.3.10.c.3. This is the Cape Cod berm. Do I need to read this one? Okay, we're all. See if you're.
I'm fine with
Ag.
that.
Waiting hard, Cape Cod berms.
I give confirm as opposed to what's directly in the design specs is in the public interest.
I'm fine with it too. Or, yeah.
Agreed.
Cape Cod berms,
I have no issue with this waiver request.
great, thank you. And then the last one is the shade trees, section 11.0 shade trees. Due to the existing density of the frontage of 51 Wadsworth Road and the narrow 18-foot wide driveway access, there are sufficient trees of all sizes that will remain. To provide natural aesthetic appeal and screening, those planning here is just enough land to construct the driveway, meet the roadway pavement requirements, with the intention to preserve maximum natural growth and maintain maximum privacy and screening. As the applicant plans to retain a robust natural tree line with trees that are well in excess of the 2-inch caliper requirement. It would be in the public interest to waive this requirement. The applicant respectfully requests such a waiver. All right, so Jen, we'll start with you.
I am not inclined to grant this waiver request.
I am inclined, because by enforcing this particular waiver, you're gonna, will ultimately result in more clearing. To put in the new trees, and so if the goal here in the public interest is to keep the aesthetic appearance of where we stand now. I think you're probably better off waiving the requirement. Clear more land and put, develop more, put more shade trees. So I would be inclined to grant this waiver.
Okay, Jen was no here, yes, Laura. Okay. I'm fine with that too. Wayne,
Although respectful, Matt says this provision expressly contemplates that the location, size, number, and species of the trees will be determined jointly by the developer and the directing lands and natural resources to tree warden and approved by the board. So the concern that isn't going to result in additional clearing, we think is a little misplaced, and I would vote against this waiver.
okay,
Not in favor.
right, Steve,
I'm also not in favor of this one for reasons similar to what Wayne is specifying. We just don't know which trees are gonna be saved. And which are gonna be removed.
change my mind too. Okay, so of the 9, if I've done this correctly. Is it helpful? You found this helpful? Go through if I did.
For some reason, I'd like to, sure. Yes, please.
I can tell you which 3 you're giving us. That's helpful.
All right, so let's see, the first one, water distribution, waiving that.
So, I I'm sorry to do this, but at least as I understand the subdivision rules, we have to take a formal vote on each one of these things.
Yes.
And I asked earlier, are we voting on this or are we just talking about it?
So now we can, push the vote. I just want to like.
We can have the discussion.
Yeah, we've had the discussion, let's have time to think through, so we could go back and vote on it, okay? All right. So to vote on each one, do we need to have a motion, or can we? Raise out of your head, yes?
Yeah, I think you need a motion,
Motion to vote,
I mean.
I guess we have to, motion to approve, and then we.
I mean, I think the 80-foot, 150-foot one is kind of the big one. And it sounded like only 3 people, if I understood correctly, were in favor of that one, so it sounds like that's a no. You guys can correct me if I'm wrong. And so I believe, and maybe Pat Brennan can jump in here, that they're gonna, if assuming that the board sort of holds to that, only 3 people in favor of it, which is a no, I believe, then you know, the applicants will need to do like a full set of drawings, you know, as they did before, you know, show, you know, using this conceptual as the basis, showing the 150-foot. And as they do that, some other things, you know, that'll show things in more clarity that actually might help with the other waivers. So I don't know if you want to vote on all of them, the other ones right now. It's up to you, just, it's possible that when you see the entire drawings and discuss those, you might say, wait a second, we can or cannot grant this waiver, that you might change your mind on 1 or 2 of the ones, you know.
No,
I mean, I guess,
but. I didn't mean to.
no, actually, I cut you off, but I guess I just to, also, I mean, in my experience, and again, it's up to the board, but in my experience, oftentimes. The waiver votes, the actual votes are often done at the very end of the process, but usually, but it's definitely a very wise idea. To sort of know where you're gonna, what those votes are gonna be much earlier. You still have the right to change, but at least now we have a really much better sense of how things, so I think this is a great thing to do. And I think now we kind of know that it sounds like there'll be 3 that are probably granted, but for the actual votes. It might be wiser to wait to then, but Wayne, I apologize, I did interrupt you, and I
Oh,
apologize.
that's okay, because I think you're right, we're on the same page here, because my understanding is that you vote for the waivers in connection with approving a plan.
Exactly.
And we do not have a plan before us that I think is going to be approved, given the failure of the straw vote on the 7.3.10. So I don't think we can vote on this plan, therefore I don't see any reason to vote on it.
Okay, but don't we have to, I think we need to essentially vote at least on the 80-foot waiver, so that then we have a definitive yes or no. That essentially means that we're voting on the plan.
No, I would not vote on that one either. I would wait. I would wait to vote on them all at the end. I guess would be nice. But I mean, I see your point that if they're gonna revise the drawing, then. I don't know if you can change your vote once you've done it. You probably can.
But if they're gonna revise the drawing and what happens is the vote's gonna change. And we're gonna go back to the smaller 80-foot. We already have set plans in like that.
Yeah, so I guess the normal process would be that they would, now that they know, they would take away the waivers that the board has kind of said they're probably not gonna grant. And so like for their next version of the project, it'll be new drawings showing the 150 feet. And it'd be a new list of 3 requested waivers, I believe would kind of be the normal process.
But their plan, the 150 is supposed to have no waivers, I think.
Well, it could still be you could still do the 150 plan and still request the 3 waivers. Because those are not really related to the, you know, the actual dimensions on the drawings, I believe.
If I may, through the chair, I believe, and Matt, correct me if I'm wrong, I believe that we can move. I see 2 paths here. One is to approve the plan with conditions. The other option is to deny it and list the reasons so that the applicant knows what waivers we would be willing to approve if the plan is resubmitted. The third option just come to mind, we could deny without prejudice so they could resubmit. Or continue.
Well,
She asked you, so I'm just gonna.
oh, was she asking me or Matthew? I don't know.
Yeah, which Matthew?
Sorry about that.
Which one?
Matt,
Mine. Sorry. Guess what?
I guess it's up to the applicants. I mean, the simpler procedure ordinarily, in my experience, would be just to, you know, to continue the hearing, to extend the deadline again. And for them to revise the drawings, create a new cover letter, a new list of the waivers they're requesting. Only requesting the ones that the board has kind of indicated they're probably willing to grant. But, you know, the applicant certainly could ask to withdraw that prejudice or do it some other way if they wanted to. That's at least, that would be my thought at least. I don't think you'd want to just vote, you know, to do on the 80-foot plan, kind of on the current plan before the 80-foot diameter plan. Unless the applicant actually says they want you to vote on that, because you should definitely give the applicant the option to redesign it.
Okay, so our options are deny this plan outright, deny with conditions, or leave it, just continue and allow the applicant to come back with it.
Yeah.
Is that what I'm hearing?
Yeah, I think the logical choice would be to continue, unless the applicant wants you to vote on the 80-foot plan, or unless the applicant wants to withdraw the plan without prejudice, to withdraw the application without prejudice.
All right, what would the applicant like to do?
The applicant would like to call his client briefly, who's unavailable for medical reasons today. But my suggestion would be that we continue this for a suitable amount of time. If the applicant wants to come back with a 150-foot no waiver plan, maybe limited to those 3 insignificant waivers that the board seemed in favor of. We still would need a couple months for Mr. Green to prepare a full plan set, showing that 150-foot cul-de-sac layout. So we would need at least a couple months. I think we could continue to come back with that. But my client may prefer a down vote just to get this over with. So can I call him briefly in like 2-minute recess? Yeah, thanks.
The board, I want to make sure that, we mentioned 3, but I want to make sure I understand kind of what we, the first one, water distribution was straw, yeah. The plan profile and cross section was, that was 4-3, yeah. Is that right? Environmental impact assessment and do not waive. As-built plan, do not waive. Roadway acceptance plan, okay to waive. As-built plan and roadway acceptance plan, we want securities, do not waive. Eighty-foot was no. The Cape Cod berm was a yes. And waive it, the shade trees were no. So there are 5. All right, thank you.
Yeah, I think it's number 1, number 5, and number 8.
yeah, I think I'll.
As-built plan security was, oh, do not waive, do not waive.
1, 5, and 8 were the ones that I think we agreed, but we were inclined to waive.
Sorry, what, Jen?
1, 5, and 8 are the ones that we generally agreed that we were willing to waive.
Yeah, that's what I have too.
I had only on number 2, it was tag Wayne and Matt did not want that one. Anybody else?
That one I wanted to
We
change.
can go
Oh,
through
you
it.
can change your vote.
Yeah, sorry, that was the infrastructure one, right, with
Yeah.
the retaining walls.
Okay. Perfect, thanks, Jen, you got that right on the head. 158. Yes, sir.
Can I ask a question? How do you know when they say they're not gonna cut down any trees that are unnecessary to be cut down? How do we know that they're not gonna come in and just clear cut everything? What do you do if they do that?
Well, what we do is the applicant goes out with the developer, or the applicant goes out with a tree warden, they actually tag the trees, they put little ribbons around them. And then the tree warden knows where they are and they, you know, aren't supposed to come down.
So what happens if they cut them down? Can you stop the project?
That,
Well, there's potential.
I mean, I guess you could ask that question about
any project.
any project that, gets, you know, what happens if the applicant builds the house, or what happens if the applicant builds the building on some other part where they didn't show it in the drawings, I mean, that's, it's up to the building inspector, who's also the zoning enforcement officer, and the building, you know, to enforce things by.
No building.
Putting it down the road, bringing the police, I mean, they've got the authority. But I mean, I guess with regard to that question, I don't know if you can, I don't know to what extent you can, sort of, put a restriction.
Through the chair,
I do.
the consulting
Thank you.
is pre-construction, during construction and post-construction that would address that.
All right, Mr. Brock, you have any?
Yes, on behalf of Council D'Ambrosio and Eric Fonka, if our client, we request a continuation.
How long would you like?
At least 2 months, second meeting in January.
Second, sorry, say
And
again.
obviously, environmental impact assessment, the roadway details, stormwater calculations, as we did once before, have to be done again. And obviously, I would even suggest if you haven't been out to the site, if we could just schedule an official site visit, we can explain to you the reason for some of the variances that you've already non-supported here, and we can explain to you who we've talked to, why we want to do what we want to do, and the uniquenesses of this site. Because quite frankly, you have 2 corner lots. We're not creating any more lots like a 3-lot subdivision would create. We basically have 2 corner lots here. We just need a little bit more frontage. So we're trying to minimize everything, as we've been saying since January of this year. Okay, thank you.
I think some of us were able to go out, so maybe we could schedule another time for some other members. So that
Okay, leaves it down. It's easy. It's easier right now.
Yeah. Is the poison ivy gone?
Sometimes poison ivy is worse in January, I can tell you that, all those people that get it, okay? Mhm.
All right, well, thank you for your patience and working.
We'll put on deep roots.
So I think, sorry, I think you do need to
Yeah, oh, you
to,
did.
but also to vote to extend the pesky deadline.
Yes.
And so, I don't usually do a form and that hard copy form or whatever. But I mean, at this point, maybe you can, if, I guess Paul can verbally agree to extend the deadline, so maybe I don't know. January 30th or something, January 31st, maybe or something like that, and the board can vote to agree to extend the deadline to January 30th, or whatever, you know, whatever day you choose, January 30th, February 5th, whatever.
I'll come in the office on Wednesday. Yeah, tomorrow's a holiday, I'll take care of it.
Do you,
I'd like to move that we extend the deadline or request of the applicant that they agree to extend the deadline until. I'm gonna say February 10th, because that allows us to have a meeting on the night.
Second.
February 10th.
any discussion? Okay, then we'll call for a roll call vote, starting with Jen.
Turcott, aye.
Matthew Ray, aye.
Kristen Rabbi.
See you again,
I think the applicant's representative needs to verbally confirm, agree with that to extend the deadline for February 10th also.
Thank you very much.
I'll take that as a yes.
Yes.
Oh, yeah, also, but we can.
What's the end of the second?
January 26th. Or the first, or the second.
All right, I would move to continue this 13 lots with road subdivision. Public hearing until January 26th. Second.
Can you just vote on this?
No.
You just voted to extend the deadline. Now this is
Oh,
the.
okay, I'm sorry. Okay, next up, all right, so we have seconds, any discussion? All right, we'll call for a roll call vote, starting with Jen.
Turcott, aye.
Matthew Ray, aye.
Kristen Rabbi,
See you again, aye.
and the motion passes. Thank you.
Thank you.
Thank you very much.
Thank you.
So the next meeting for this is on the 26th of January,
Yes.
is that correct?
Thank you.
Thank you.
Agenda item number 3, public hearing for 153 Northwest Street, 80 administrative site plan review. This is actually a big day for the planning board. This is actually the first time you've had a public hearing on an ADU. So I'm just going to give a little prologue and give you I'll make sure to talk in just a second. So this is the first public hearing of the planning board for administrative site plan review of a proposed ADU accessory dwelling unit under the zoning bylaws new rules granting more flexibility to ADUs. Administrative site plan review and a public hearing are required in case because this is a proposed ADU might be is in a newly constructed building. So with that, would you like to tell us a little bit about your project, please?
Right,
Yeah.
question first. Has the Attorney General approved
No.
this bylaw?
So the Attorney General, the Attorney General is kind of strange. The Attorney General did approve the MBTA communities, and then the Attorney General approved, I believe there were 2 separate warrant articles for ADUs. One of them and not the other.
That would have otherwise banned. But we had a whole series of these I presented, we had a whole series of some standards that are administrative site plan review. That I don't know the Attorney General has approved. So if the Attorney General has approved them, we don't know how we're imposing.
So town council did advise
Okay,
that once they're passed at town meeting, we can go ahead and go with them. We can go ahead and go with the assumption that those have now become part of the zoning bylaws. However, an applicant kind of proceeds at their own risk because, and I think I mentioned this to the applicant or the applicant's representative when they originally submitted it. Because if the Attorney General, and this would go for any zoning bylaw, if the Attorney General ultimately kind of rejects it or denies it, then, you know, at least in theory, the applicant could have to like tear down anything that, like, then the planning board's approval would potentially become legally kind of null and void. And it's sort of in theory, not the matter to like to tear down something they built. Now, I think in this case, because the state law already has taken effect, I think back in February, even if we had never even amended our zoning bylaws, even if the Attorney General rejected this, whatever, because the state law now exists, they would still have the right to build the ADU, even if we hadn't changed our zoning bylaw. Like even if the zoning bylaws said you can't build this ADU, by state law, they would still have the right to build it. And in fact, they would be in a position where they could just get the building permit without having to go through the planning board at all.
which is the exact, this whole notion that they somehow are building at risk. I don't understand it, frankly disagree with, because if our administrative site plan review bylaw is not effective, then you just go get a building permit.
I think that's probably true, yeah, probably, yeah. I think we're, yeah,
It is true.
yeah. But I think it's appropriate because it was passed at town meeting, it's appropriate for us to treat it as though it's applicable and to go through this process, I think. I mean, I think we should assume it's enforceable as it's written and as it was passed at town meeting.
Do we have a sense of when we're back from the 18 months?
I think probably the next month or so. I think they don't have much time. I mean, unless they keep extending it again and again, but I think the letter that they sent, so they'd given us like 45 more days or 60 more days or something like that. And that was like maybe a month and a half ago. So I hope this will get the word fairly soon. And it was bizarre to me because it seemed like those 2 warrant articles were kind of intertwined. So I don't quite fully understand how the AG can approve one and not the other, but that's up to the AG, of course.
Question?
No, they don't have any questions, although I do understand how the AG approval, not because one of them is a series of restrictions, and the other one just merely permits. Or strikes the provisions that would have otherwise barred ADUs.
All right, so with that, would you like to tell us a little about your project?
Steve Petrowski, I'm the managing member of the LLC that's restoring the property out there in surplus. A little background there, somebody had squatted there for about 9 years, claiming that they weren't properly foreclosed on. They finally vacated and I've been working on that since about February, I'm trying to restore the existing house.
So the house is about 5,000 square feet, and it doesn't have a garage. I'm developing this thing for another end user, and they feel it needs a garage, and as part of that process, I just felt that, with the garage, it'd be nice to have a space above it. And the apartment, ADU, the law came into effect, so I didn't know whether this could be done by right under the existing zoning or not, but it appears it falls under the ADU. So proposing that, I don't suspect that this is gonna be, this home on surplus with this, I don't suspect somebody's actually gonna be renting this out to somebody else, but I don't know, I assume it'd be in-law, whatever it's gonna be, but that's the plan anyway, just to develop that, to have kind of an apartment for an adult, child. Or reside in it there.
Thank you very much. And have you built any ADUs before?
No.
It's a first for both of us, to talk about this. So, does the board have any questions?
My question continues to be. Under section 32 of the general laws, unless the attorney general has approved it. Or the 90-day period has expired and not been extended. If you told me it's been extended. It's not enforceable. No, it is presumed not to be enforceable.
You've got two different people.
I don't. I don't know who's, that's not what Amy said.
This
This is the language of section 32.
Well, there you're making a mistake of reading the law.
You're like, I'll read what she said.
Oh, yeah, do you have that,
Yeah.
Yeah, I have it right here. So, that you asked about this question. That age. So amendments to the zoning bylaw are effective upon vote of town meetings, CGL, section 40A. 40A, section 5, which states in part the effective date of the adoption or amendment of any zoning ordinance or bylaw should be the date on which such adoption or amendment was voted upon by the city council and town meeting, and it continues. However, the zoning bylaw amendment still has to be approved by the AG pursuant to general law section 40, part 32. In my opinion, any permit application submitted after town meeting, but before the attorney general approves the amendment, will need to be acted upon as if the zoning bylaw amendment has been approved by the attorney general. Any deviation, for example, if the AG disapproves some or all of the amendment, is at the risk of the applicant. If the resulting permit is in violation due to the AG's determination, zoning enforcement can be applied. Thank you, Amy.
All right, well, I think at the risk of the applicant is actually a non-issue.
I agree with that.
And we've got advice to town council, and I guess we're gonna go with it. It's not the way I read it.
Any question, please? The ADU approvals is up to 900 square feet, right?
Yes.
How does this go for the 900 square feet? Because it's more, the garage, that's 890 with 900 above it. So above the threshold.
So, right, so it's just the second floor that is applying for the ADU. And so that is, looks like it's right at 890 square feet.
So would the garage be able to be built without the ADU above it?
Yes,
Do you have the right to do that?
yes.
I did have some questions. I knew that there were, and some of this again is kind of going back to, this is the first time for us as well as for you to go through this, so. Typically we've got a new construction, we like to see a lot more on the plans, so I think you might have already talked to Matthew about.
Yeah, I appreciate that. There was a couple things that I see you could want a little more
Yeah.
information. I don't know if he provided you some of the markups that were done there, but I figure, I don't have a construction set yet for getting the permit plans yet. I kind of want to go through this process and avoid.
I totally understand that, and that makes sense. So the first thing we would want to see a driveway, so we want to know how is that applicant gonna get there? How's the person who might be staying there? And one of the questions I had was, or I have a couple of questions. One of them has to do with when we look at the property, And so this is the property, this is surplus running top left to down to the right. It appears there's a driveway here. So would the driveway for this new garage come off of that driveway, or does the driveway belong to this house? See a head nod.
Are you talking about the long driveway that has a grass strip? Or are you talking about the driveway on the right side of the lot, I guess?
The right-
Eastern.
The right
eastern-
side of the lot?
Yeah,
I
so
think the new garage would be down here, right?
The garage, so the existing driveway is gravel and goes right by, that's the kitchen side of the house, the right side of
Okay.
the house. I guess that's actually the western side of the house, but, so the driveway will continue along that same line, curve just a little bit in order to capture
Okay.
the garage.
And it looks like is there a driveway that continues on past, beyond the property? I guess that would be south of the property.
The other driveway's a neighbor's, they got almost an ADU at the street for some kind of a, I don't think it's technically an ADU, but I think somebody separately lives in this home
Okay.
right on surplus, and then there's a long driveway that goes back to their home. And between the two driveways, my driveway and the other driveway is a hedge line.
Okay.
And so it's that may be the driveway you're looking at.
Yes, okay, and so that's part of, one of the things with the ADU, when we were writing it, is we wanted to make sure that, when it was built, that the primary house had privacy, and that whoever was staying in the ADU also had privacy. And so one of the questions was, one of the requirements is that we actually show, that the plan actually shows some features such as, there's actually, I don't know if you had a chance to read through the bylaw.
I
yet.
did, I thought that it referenced a certain distance between the structures.
Yeah.
I didn't see anything in terms of hedging, and so that was, I thought, to do with neighbors, if you're gonna be within 15 feet of the lot line, or you're gonna have trash outside or parking outside.
Right, and there was there are a couple of things. One, that we would want it to show consideration of the surrounding area, so the plan would include general characteristics within 100 feet, such as structures, parking areas, driveways. Also, there is a requirement to show where the recycling and the trash would be. And there's a question about the balcony too, because I think the way it's situated, it faces away from the main property, but it faces the backside, which is another neighbor. So then how does that, what we want to be able to understand is, how does that impact the neighbor? Is the neighbor within 15 feet, and they may not,
Yeah.
they figure that out.
So, for what it's worth, looking from that corner of the property, looking back at that neighbor back there, there's a bunch of pine trees and growth that does block and, for what it's worth, all their lighting and stuff seems to be on the center or the right side of the house. I was just there this evening and looking through, I didn't see any lights on in that corner, whatever it's worth, but it is off to the corner. I know the zoning bylaw, the proposed language talks about that the deck shall not face a residence. I don't know what the exact language is, but I mean, I think no matter where it's facing, it's gonna face a residence, I guess. So I don't know if that was intended to be, will not face a particular home, an actual home as opposed to a residential lot, or what the objective was in that language. You guys, I don't know how it'll come back from the AG, and I don't know if you guys want to look at it more closely, what's intended there, but I kind of assume that you didn't want it maybe facing directly at a house, maybe a nearby house. I don't know. So again, I don't suspect this is gonna be college kids living there and whooping up, partying in the back deck, but it is self-facing. It'd be a good spot for, for sunbathing, for a grill up on that upper level, for plantings or whatever might go on up there. So that was the intent of that, definitely.
And I think there's sort of some, and you don't believe the personal interpretation, it's should not be oriented to facing everybody residential, so as use it should not intrude upon the privacy of adjoining properties. So I think one of the other things too is that, I think Matthew, you talked about the one more detailed plan that has, so I saw the handwritten, that's great, that's helpful, but ultimately we need a more formal plan.
Yeah, I guess the one thing I would say to that is, I think at least in my experience, usually for single family house properties, the developers or the builders, the agents usually don't have professional, they don't actually have sort of civil engineers working for them the way they would if it's like a commercial project or whatever. And so maybe it's, if the board wants a sort of a better drawing, that might make sense. Obviously, some of these were kind of crude. But I think there's probably no need, unless the board feels strongly otherwise, there's probably no need to require that actually like a professional engineer drawing with topos and all that.
You could just be, more information, maybe not a professional. So, anybody else have any thoughts?
No, I think you hit, I think you hit on a lot of the questions that I had there too. But, I think the highway safety advisory, group, they indicated that the plan should also show needed access to surplus feet. So we certainly want to see that.
And so that would just be continuing, like actually showing us the driveway, except from the picture, just that's why I couldn't tell.
Right.
What driveway was where.
Yeah, and I did provide maps on, but I don't know if you
Yeah.
pass them on, it was one of my kids drew a driveway and then, you know.
Oh, okay.
But
That's what we saw. Right, yeah.
that's where the driveway is gonna go, so I mean, I can have my architect, you know, sketching lines there, I guess they're not gonna look much different, I guess they'll be a little smoother.
Okay. Okay.
Yeah, I mean, I think I wanna make sure that we're being clear for the applicant, what the ask is, and my perspective, I don't, as far as who draws the lines, it doesn't matter, but as long as all the lines are on one piece of paper, that's really.
Yeah.
So bring it into the drawing.
Yeah.
I mean, you've already noted the concern about elevated decks, and so here, it doesn't seem that this is a concern for this application, so we could make it lot, but the only question I would have is if it's a buildable lot and somebody ends up wanting to build a house there in the future, and then we get. But that's eventuality, we can't do anything about it now.
Yeah.
So it seems fine. You know, he builds those sites.
That's his problem.
Yeah.
There is a tree house back there.
That's right.
Is it on your lot?
No.
Is it on your lot?
No, it's the, yeah. Lauren?
No.
Matt?
I would just say we, as a board, need to be somewhat careful here. I agree with Wayne and reading the statute.
Yeah.
I don't necessarily agree with Amy's recommendation on this. I don't think the bylaw amendments that have passed town council are yet law. If I was representing the developer, I'd say you could go in and get a building permit on this tomorrow. Not in the spirit of, he's here and we are discussing the requirements of the amendment that was passed at town meeting, which I think is helpful. But until it's approved by the AG's office, I don't think we can enforce it.
Jen?
I agree with Matt, Ray, and Wayne, that I don't have any issue with what's been submitted. It's just a question of where we are legally.
I guess the only, but this is very similar, at least in concept, to what we had at the MTA communities law. Where, we adopted the bylaw amendment. And Amy's opinion there was, if we would adopt it at town meeting, then we submit it to the AG reviews it. And then if the AG comes back and says, no, you have to revise it, then we would still be, the bylaw as passed at town meeting would be in effect during that interstitial period between passing and the AG's opinion. The bylaw would be enforceable on its terms. But, again, that was Amy's opinion, and I think quite frankly, that's consistent with what she's defined here in this situation as well. I mean, not an attorney, but, I don't see a whole lot of difference between the two situations.
Also, I mean, I think if the applicant were to go to to the building department and apply, for a building permit to the, apply to the building inspector for a building permit. The building inspector would probably say, and maybe the building inspector has already said this, the building inspector would say, here's our new zoning bylaw, you need to get approval from the planning board. And the applicant probably doesn't want to sort of, contest that in court with a lawyer and so forth. And so in that sense, I think it seems to me it does make sense for them. Even if maybe some of the planning board members kind of philosophically feel differently, it makes sense to review it in that spirit, I guess, is what I would suggest.
Well, I'm happy to review it.
I mean, I guess when I say review it, I mean like actually vote on it as.
So, how would we like to proceed? We have some recommendations. Would we like to continue this? Ask the applicant to, maybe make some changes, come back, and then maybe within that time, the AG will approve it.
My understanding is that you have 90 days and they don't do it within 90 days, then it's lawful, but they can ask for another night.
What do they do for their 90?
I don't know, they asked for another night.
Sorry, I don't have that, I don't think I got the. We probably got it under email somewhere, but yeah, I can't remember.
If I may.
Yes,
So I believe the ADU language, obviously, maybe not obviously, but the town's language is more restrictive. So if I meet that, you know, and the AG blows you guys up and says you can't tell them they can't have a deck facing this way, that way. So be it. I feel comfortable with that. I'm in good hands, you know, that way. And I would like to suggest that, I don't know what else is required for plans or whatnot, but I would like to, ideally get approval contingent upon, you know, plan with the line. I don't think there's much more to add than let me know, but I can produce that in a week's time or whatever it's gonna be. I prefer not to have to schedule another hearing so I can move forward with you know, get the ball rolling with construction plans. And try to get ahead of game.
As was mentioned, you know, we're concerned here in terms of ADUs and, just, you know, the fitting in neighborhood. And you have this, but a dimensional requirement, you have the height of the new structure listed at 27.6. Can you tell me the height of the existing structure?
Ken, I don't have it.
It's like a tough question off the head.
I'm sorry?
It's like a two-story house with
Yeah,
pretty good gable, so.
but I mean, for what it's worth too, I trust that, you know, the building commissioner's not gonna say, oh, they approved the ADU, so I mean, he's gonna look at the heights and everything. If I get it, that's gonna come down. You know.
Oh, yeah, I'm not suggesting in terms of violation, just to understand the proportionality, because it's.
Yeah, no, it's proportional. It's not well above or anything. It's a two-story.
So with 900 square feet, you're gonna have some things that are not exactly the same size, you know, they include. Put underneath.
So I think, do we want to approve the condition, or do we want to have the applicant revise the plans and come back?
My preference would be the latter.
We could enumerate the conditions succinctly, maybe, but I'm not sure. Want to throw it on.
My recommendation would be, we agree on what conditions we would require. I don't think we can approve it legally today,
Okay,
but we can tell the developer, so he has an idea of what, so that he knows when,
Which way to go.
what we're looking for in terms of presuming under the assumption that the bylaw gets approved by the AG's office.
here, we'll come up with a 16 list here. Should we do that now? Here quickly. Looking through the bylaw, done the public hearing, so I'm gonna look at number 11, which is site plan review. So public hearing, we've done that. We've been due to hear from the butters here. And just, so actually, why don't we pause here for a second? I think we have some butters, and we'd like to, is there anything you would like to say?
Yeah, a couple things.
You have to, would you mind giving?
Jeff Warren, 150 Surplus Street, across the street. First of all, congratulations, I'm thrilled you had the resilience.
Please make it nicer.
to stay with it, for however long it was. We're thrilled that you're doing something there. Yeah, I was just concerned more than anything else with because of the bylaw. I'm concerned that there was not gonna be potential for having a rental unit across the street from us. Short-term rental unit across the street from us. That was not gonna, I have been spirit bloody murder. But that's, I don't know, foregone conclusion, assuming the age.
So as long as bylaw gets passed.
Yeah.
That's.
I mean, what affronts the AG about the bylaw, you know,
So I think it could be, I think it could become maybe not a short term, but I think it could become a rental unit, and I don't think the board could.
a rental unit, I'm fine with,
Could prohibit that.
but Airbnb, I'm not.
So for short term, I think is our general bylaws prohibit short term? I think we've got some bylaws.
Less than 30 days.
I don't think it's 31 days.
Excuse me, your ADU language prohibits it, I believe.
Yes, it would.
I think your proposed line,
The proposed language does, yeah, no problem.
But I think that would be outside of the planning board's jurisdiction regardless.
Yeah, so if you're telling me you're gonna build in accordance with the bylaw anyway, yeah, you're gonna apply the bylaw anyway, whether it's. Between now and the time the AG wakes up. And you're willing to share the plans with me offline, so I can see what the hell you're gonna do, it'd be great. Oh, good.
So when the ADU law got passed, they specifically said that you couldn't bar rental, general rental.
Yeah.
But that you could pass a bylaw that limits short-term.
Yeah.
So that portion of our bylaw, I can't imagine being struck because it was expressly authorized in the law.
Were there any other things, Jeff?
No, I'm gonna talk to them
ADUs can have
True.
kitchens, correct?
and they have to.
Anybody else here for the ADU?
Just by the way, the full application materials are on our website, so you can see them there as well.
Sorry. All right, so thank you for coming. Welcome to stay. I'll just, so we'll run through the list if that's right.
Can I ask this question?
Yes, sir.
About ADU, you said the guidelines online, can you get what you can do and what, distances and stuff like that, size, all the guidelines, are they available? Or you have to go to the building inspector and talk to him?
I mean, the easiest thing is probably just to call us or come to our office. I mean, I guess you could find them in the old warrant article. I don't know if they're. Oh, I guess you can also get them on our website because we included them with the materials for this one. We haven't yet actually put them in the zoning bylaws just because we're waiting to hear from the AG on the second part of it. But we can easily get them to you one way or the other,
Yeah.
It's about 2 pages, of text really, so it's pretty short.
All right, thanks.
So on the town of Duxbury bylaw, there's an accessory dwelling unit bylaw that reflects it was approved on June 2025. So it is available.
So it tells you that
Just search Duxbury ADU bylaw and it comes up.
it's all detailed.
Yep.
Okay, good.
All right, so let's go back to the site plan review. So if we go back into its under 11 site plan review, so A is a public hearing, B, plan shall be submitted to, you should be drawn to a scale of 1 inch, which is fine, that was done. Although it does say the plan shall depict the location of all existing and proposed easements. Are there any with the property? No. The plan should reflect all existing site features, including the size of the property and structures. I think you have that. D, a locus map shall be included to indicate the location of the property within the town.
That was a thing about.
Please, Bishop?
Yeah, I would say so. I mean, I guess kind of goes back to what I said before, like if this was like a commercial project, was drawn by, a full civil engineer, we might be a little more stringent in how we define locus drawing.
That's.
And so Matt, I'm sorry. My reading, the site plan review specifically requires a plan drawn by a registered professional engineer or professional landscaper.
That is what the site plan is by a.
Okay, perfect.
Oh.
Yeah, he's done the same.
Got it.
Actually.
That's what it is.
Is it surveyor?
Yeah,
Okay, E, in order to allow adequate consideration of the surroundings, a plan of adjacent property shall be presented. Plan should show the general characteristics of all lands within 100 feet of the proposed site, including structures, parking areas, driveways, pedestrian ways, and significant natural features. Is this sufficient? No, is this sufficient for us?
I guess that's up to you folks. I don't know if you read the, I'd say probably yes. I don't know if we could read that part again.
Sure, the plan shall show the general characteristics of all lands within 100 feet of the proposed site, including structures, parking areas, driveways, pedestrian ways, and significant natural features.
So yes, I think that's one of the things I asked him to clarify or resubmit, and he did submit that other, I don't know, I guess it's like a satellite drawing that kind of has maybe I don't know for a child.
Yeah, I had been marked up, I guess, I don't know if there's
So it
really much
doesn't
to
look-
show, there's no natural features that I'm aware of, there's residents, there are there's no parking lots, there's driveways that are visible in that.
Well, I think it's more, a more refined drawing with the, like the shrub, with the hedge between the two driveways, like that would be helpful to have.
Okay.
Yeah. Anything else, any more definitive?
I think that makes sense to me, and just something that looks, I mean, I don't think the board is asking you to hire an engineer, but just maybe to make it look a little clearer. And
Yeah, we'll go along with the driveway.
Plan shall, F, the plan shall indicate all proposed buffer screening landscaping along designated areas for trash and recycling. I think that was not on the plan.
Well, and on the application, it's make the trash and recycling be in the garage, so, and I don't know if that sentence finishes with if the property is within 15 feet of the lot line.
It says any parking outdoor storage areas which are associated with an attached protected use or within 15 feet of the property line.
Yeah, and nothing's in within 15 feet, it's all set back.
Okay. It's inside, it's inside.
Yeah.
All right, G, the detached ADU's exterior lighting should not cast a glare onto adjacent properties, and this was, we were looking for something that didn't project up, but kind of more down, is that fair?
Yeah. Oh.
Yeah.
Eight, any exterior decks or patio shall be located so as not to intrude upon or generate excessive noise to adjoining properties. 15 feet within. There's the end of lot, the building house. Second to last one, if the detached ADU incorporates an upper story balcony or roof deck, such balcony or roof deck shall not be oriented to face any abutting residential use, which I think we decided not correct, okay. And then the requirements of zoning bylaw, section 615.7 shall apply.
Are those just the rules for site plan review? What's it again?
No, site plan review is 615.
615.7 is the procedures, essentially.
Okay, just out of,
So 17 copies are required to set one sheets. Copies.
right, anything else anybody wants to?
Do they need to show the septic, the new septic form?
Is that what that is?
That's the
Oh.
leaching field, so this is the existing for the house, but I don't see that, the new one.
Yeah, we have a letter from the Board of Health indicating it requires conditions.
It doesn't.
So it does require conditions. So I think that will go on the site. Are you aware of that letter?
Well, yeah, I mean, so I had a lot of conversations with Lauren H and, yeah, she approved, she said it's fine, you just have to put a 1,500, gallon tank or whatever with 2 compartments.
Yeah.
And so forth, and that, my understanding, is only part of the construction plan process, that's not part of the ADU. I believe Matt had confirmed that, but can you speak to that?
Yeah, it doesn't say it has to be on the plan, it just says adequate provision shall be made in accordance with the requirements of the Board of Health, which have that.
Yeah, I don't think it needs to be shown on the plan.
And as long as the Board of Health is signed off, right?
Well, that'll be a separate process that you'll have to go through. Yeah.
That's a good point. Yeah. good enough. Anything else? What? Does that help?
Yes, you guys want shrubs in the driveway?
Yes, I think, it sounds like you know what they want from you and could just continue the hearing probably until November 24th, if that gives you enough time. Then I would see what a lot.
Okay, all right.
Yeah,
There's
well,
no way,
can I ask the question just in favor of the applicant? Given that what we've asked for is a little bit of additional detail on the plan. And it doesn't sound as if that additional detail would be material to the question of whether we approve the plan or not. Just want it on the record.
Just want it on the record and have the staff review it.
Well, would it change our decision?
Change the decision.
To add the driveway to the plan? Is that gonna provide new information that would alter our thinking and maybe correct our vote? Because if it's not, I don't see, to your point, I don't see the benefit of having to wait another week since We're really just asking. But I don't violate, procedure, if it's more appropriate, or,
Yeah, we are,
Overthinking.
no, I think we're requiring them to come back with a plan for, a bylaw that's
Okay.
not approved, so to Jack's point, we could approve the plan as is with those additional conditions that have to be administratively approved.
If I may, I don't know, I should have brought one, but I don't know, did anybody get a copy of my chicken scratch with the bush line and
Yes,
the
we have.
driveway?
Yeah.
Can you make that a condition of an approval that a proper plan will reflect this?
Yeah, I think that's what Tag is suggesting, just simplifying it to just if we approve a condition on you doing that, then the staff would review it and make sure everything is that fair?
Yeah, and I think that way we would have, if that's sort of condition, then we'd have, the staff would have the authority to say to the building inspector, wait a second, you can't issue the building permit until they've fulfilled these conditions, as would be with any decision with conditions for a site plan.
So the motion would be that we will approve the proposed ADU condition on submission of the plan that is deemed sufficient by the planning staff.
I mean, I guess maybe a little more specific that you want them. The extension of the driveway properly shown. Properly and precisely shown on the drawing, as well as the things within 100 feet of the property boundary.
Buffer strip.
But yeah, basically, yeah.
Landscaping.
As Tag said, it's pretty kind of minor stuff at this point, but still important.
And you could just require.
Yeah, I think that would give Emily and me the sort of the authority to, yeah.
I don't have to go through the motions. You have a motion?
Well, Wayne, I think you made a motion and then Matt, you kind of embellished on it. So
I guess.
I think
I don't
you
think
need
I-
to merge them.
I'm not a board member, so I don't think I have the authority.
I amend my motion and my motion to reflect whatever that's.
We get a little more pie. For Emily.
I frankly, my view is that I move to have to approve the proposed ADU condition on submission of plan that is sufficient for purposes of the planning.
Second.
Any discussion? All right, so seeing that Jen is no longer with us online, I think we can just go for a. Yeah, although I can do a voice.
All in favor?
All in favor?
Aye.
Opposed, motion carries.
Thank
Thank you
you.
very much. Yeah, congratulations.
Just go work on that.
Yeah, thank you.
Thanks.
Good luck. All right, next up, our third public hearing tonight. Thank you all so much for hanging with us. I did try to move, we did try to move you up the agenda. So third public hearing, agenda number 4, hearing for 774 Tremont Street, Mayflower Cemetery expansion, the administrative site plan review and late hearing and grading special permit. Would you like to talk to us about your project?
Would you like us to come closer or?
We'd love that. Softly lovely up here.
Bring my notes though.
Okay.
So thank you, being here and sticking around for us. My name is Eric Remus. I'm a time bond civil engineer representing the town of Duxbury Cemetery Department. Bob Hayes here with me, a trustee, and online we have Esna Maneva, who is our principal landscape architect, as well as Sheila, yep, still on here, Sheila Sigarzi, for the APWBW. So we're presenting for administrative site plan review, as well as a site alteration permit for the development of a existing portion of the Mayflower Cemetery. Will consist of the creation of 3,818 burial lots
as well as 464 cremation lots. Thank you. So you can see the existing portion of Mayflower Cemetery here. We're working in this existing field, right adjacent to us right now. Excuse me. Project will include associated site improvements, bituminous drive aisles, stormwater improvements, landscaping upgrades, including invasive species control, some walking paths through the site, stormwater improvements, as well as some minor utilities such as hose bibs throughout the site for watering flowers and such. I'm happy to get into as much detail as possible. In the interest of time, I'll keep it high level for now. We did receive our third-party review comments from Mr. Brennan, which we very much appreciated. We have no objections to any of the comments that were included in that review. We'll be providing a formal response to comments and revised updated set of plans based on the review comments that were included in the next day or so. That's the project. Like I said, happy to, we can do a plan flip, or we can just open up to questions you have. Happy to get into any more detail on storm drainage or what.
If you hold on your question, we'll ask questions and then we'll open it up to the floor. All right, anybody from the board have any questions?
Madam Chair, if I may, would this proposed development require any infrastructure upgrades for the existing cemetery facilities?
No. Yeah, we're actually taking, the only, I would say, tie into the existing site is the storm drainage. So right now, a large portion of the stormwater from this area here discharges into the center of that grass area. And we're picking up that storm drainage and infiltrating that into the ground. There's a series of underground detention chambers and an infiltration basin. But that's pretty much the only tie-in utility and infrastructure wise to the rest of the site.
Thank you.
No questions.
Right.
Have you ever saw that there was this church compliance statement?
See that interesting? Yeah.
That was interesting to me.
Massachusetts stormwater bylaws, yeah.
Laura?
Oh, I won't answer my question.
Matt?
No, I didn't have, nope. I'm good.
So I have a question. How long have you been working on this project? What's the plan? What's the trustees? How long has this been in the works?
Yeah, we started with a master plan for this area. I've got the dates here. It was 7 or 8 years ago. And got an architect to provide master planning. Which included not only this type thing, but also an addition to the columbarium, which was the smallest part of that. So we addressed that first, but the town was unwilling or unable to do that. So then we shelved that, and about 5 years ago, we started on this plan. And it's been on the capital improvement project for those 5 years, hopefully for the 2026 annual meeting. We then had a search for an architect and hired, after looking at architects, hired Harrison, which is in Tie and Bond as the engineer.
Halverson Time Bond Studio, they call Halverson and Time Bond are one, yeah, just.
And so that was a couple of years ago, and we've been working on it ever since. And we hope to go to town meeting and get it approved in 2026. It will then take probably certainly 18 months to be ready for sale. One of the things we've been tracking and hopefully doing it accurately is that if that takes us into 2027, which should presumably will, we will be running out of graves in the existing cemetery. So this is very much needed. We have been watching it very carefully. There are some things we could do, which we don't want to do with respect to meeting that deadline, such as limit the number of graves we would be selling. But we don't want to do that, but if it works out correctly and we are able to get it started after the 2026 town meeting, we should be okay.
And so one of the things that's helpful, that's helpful, I figured that this had been in the works for a while. One of the things I noted that is that the permit request is for the 30,000 square feet of clearing, that it looks like nobody probably, is it 2 acres?
Yeah, it's just under 100,000 square feet of clearing.
So that's more like 2.5.
Yeah, 43,000 is 1 acre or something.
I think one of the reasons I asked was because I was a little surprised I hadn't heard about this. And so I kind of wonder too, when it comes to clearing land here in Duxbury, people get a little nervous, they don't really like it. And so I wonder if it would make sense to prevent, to bolster the story and the plans, if maybe there's a little sort of PR or something like that about this project, because although it will benefit people later on, right? In the meantime, it will be a change and
Absolutely, and no offense, and it's not 20 acre.
Yeah.
We've been waiting for this process
yeah,
for a plan that but we're going to be going before the select board as soon as we understand what we're doing. We will then have publicity as well.
great.
We have been trying to tell people, particularly people that come in, that we have meeting with, we've been talking to the senior center. Well, and in addition, the plan back 8 years ago was a published plan and was quite, but people have forgotten it. No, you're absolutely
Right,
correct.
right.
And we have it in mind.
Okay.
Yeah, and we'll say too, just on that tree clearing topic, we're not really here cutting like a dense forest per se. It's more so kind of just selective clearing on the outside edge to open the parcel up a little bit. Keeping in mind that.
But I see what you were just saying.
So yeah, if you actually flip to the next, keep going a couple of 3 sheets down or so. So, yep, this is perfect right here. So if we let this load for a second. I'll jump over here so I don't impede your view. Alright, so this is that open clearing that you see right now. And this hatch mark here, we'll make sure not to touch the screen, is our limit of clearing. And then within the 30-foot landscape buffer, there's some selective clearing for invasives, white pines, as well as some invasive species control on the northern border of the parcel there as well. There are these trees here that are in the middle of the field that we're trying to keep. They're nice, mature, large trees. So anyone with this circle with the dots on it, those are trees to be protected. Any trees with the X on it are trees that are to be removed that are freestanding.
Where's Tremont? Where's Mayflower?
Yep.
On this.
So,
Is very bottom.
yep, Tremont, like, yep, right here, you can see there's a driveway entrance.
Mayflower?
Here,
Is from the top. You
Yeah.
can't see the edge.
yeah.
You can't see the fire department, but it's,
No, okay.
you can see the senior center.
Well, that was the thing I was gonna mention on your cover page.
Yep.
You've labeled the senior center as a retirement.
Right.
I noted that as well. That's scribbled on my plan right now, so we'll make that correction. Yes. Yeah, so this is where we are right here and that's.
I noticed that.
Thank you.
If I may,
Yes, sir, please.
Bill Mark, 705 Tremont Street, I live right across from this.
Yeah.
So along 3A, you've got that strip that goes up to the senior center. Are you planning on clearing that all out?
I'm sorry, which strip now?
So the shadow strip down there on the southern part of that picture?
You say this is 3A here?
Yeah, that's true.
So you've got a strip of trees along here.
Correct.
Are you planning on cleaning that all out?
So these trees with this kind of V hatch, those are just selective clearing for invasives. There's some minor clearing for stormwater improvements, but that'll be a buffer strip. Vesna, if you want to chime in at all on landscape improvements along Tremont Street. We do have a landscape plan that we could share as well. It's further a couple.
Yeah, and I think the idea there was that there are some larger pine trees that, you know, they will be coming to the end of their life sooner or later. So I think they could be selectively removed. We want to leave all the deciduous trees, the oaks, the understory as much as possible in that strip along Tremont Street. The triangle that is further south along the senior center, that is not being developed.
Yeah, that's this over here. That's all remaining as undeveloped.
That's Dennis Eco, 671 Tremont. That's what I'm interested in, that little.
Yeah, so if you go back to the color sheets,
The triangle, the panhandle.
yeah, that's not, and there's no plan development currently for that.
Yeah.
That's my main concern too.
Yeah.
Because that's a buffer for us for the senior center and what goes
Okay.
on.
So is this the complete project? Is this the remaining part of the cemetery? Or is there anything else to be developed after this?
Absolutely.
Oh, there's more, okay.
Well, I mean,
I mean.
maybe not in my life.
Oh, okay, okay. But I didn't know if like we're talking about it, you know, fair amount of size.
About, we hope about 35 years. Of burial.
What part of, where would that be shown on the map? Where is that undeveloped area currently?
Oh, it's not on that map, but it is, in fact, there is a portion here. Here is the current facility, the columbarium, I mean, the crematory.
Yeah.
And then up here is the maintenance building. In here is area that will be developed. Whoops, I didn't mean to do that. Sorry about that. In here is, and then the next development, and this will be another 10 years maybe, so maybe we're up to 40 years. After that, we have land, the town has land, cemetery has land, all back here, but it is extraordinarily expensive. And I don't think you want to know how much it's going to cost to develop it.
No, I was just wondering to a point of.
I'm only positive I'm not gonna forget about
Me
I'll be here, hopefully.
neither. Eric's gonna take care of it.
So just to confirm, that dog leg coming out, that's gonna be untouched in front of the senior center.
Yep,
Not
yeah,
for-
Not forever, but.
as part of this project, yep, so.
But I can show you what, we don't have the money to do it now,
Yeah.
but I can show you what we hope it would look like ultimately.
And ultimately would be when?
Again,
A ways up.
a ways out.
A ways out, could be 5 years, 12 years,
25.
25?
We don't have to worry about it right now.
Well, that's what I'm asking.
Yeah, no, it sounds like we might.
Well, again,
Well, it's in this map, that's why we're concerned.
I understand the confusion.
Yeah.
I saw that as well,
Well-
as I was flipping through and we can. We're issuing an updated plan set from third-party review comments, and we can figure that out, that here's the delineation of our
Okay,
project,
that'd
and
be
that
great.
white portion that we reviewed.
Now I understand your question.
Yep.
you know, I understand your concern, but when it's to be developed, at least in the master plan, it's to be developed like that.
And Eric, you.
But that master plan that's not part of this application, right?
There's no one, I
When
don't,
you say like that.
Yeah.
The triangle?
But right now, we're only concerned with this applicant, this project for us right now. This-
So Eric, you mentioned invasive species more than once. Could you elaborate on that, please?
Sure, so there's a couple existing soil mounds, kind of towards, I think this is the east of the site. Where there are knotweed and other known invasives in those soil mounds, so that all needs to be managed properly before we can, move soil or dispose of any excess soil on site. And then same, I think, along that border between Mayflower Street and the site, strictly noted for just invasive species control in that area as well. So I'm just trying to clean the space up. Be good stewards for the environment in the area and.
Great, thank you. Anybody else have any questions? So do we have, it sounds like we have, there's some more information that you're going to provide for our town, our peer reviewed, your engineer to review this.
Correct, yeah.
Should we have a motion? Should we continue the?
Maybe just give Pat chance if he wants to say.
Pat, so, oh, Pat,
Or Sheila for that.
yeah, Sheila and Pat, let's start with Pat. Is there anything that you would like to add to this?
No, I think as Eric mentioned, that there's nothing in my letter that's really that bad here. And I think that they can address those issues pretty easily. So I'd be happy to work with him if he has any questions going forward.
Appreciate that. Thank you.
Thank you, Pat. Sheila?
I don't have anything more to add.
Thank you. All right, so if nothing else from the board, I'll entertain a motion to continue the public hearing.
So moved.
Second,
Second. Oh, I get to date.
to, how much time would you,
We're ready now, so
what would you recommend?
we'll submit our response to comments. I don't know how much time you want to review those comments. But we'll have them to you this week.
We do that the
So I guess probably, yeah.
24th?
Does that work for you, Pat, if they submit theirs and then?
Yep.
You know.
Yeah, I can turn it around in a couple of days. So
November 24th, would that work?
So I moved to that date, yes.
Second.
So, we want to update, motion to continue to move to November 24th. All those in favor?
All right.
Aye. Anyone opposed? All right, thank you.
Thank you very much.
Thank you for coming tonight.
As the butters, will we get notification of that again?
I know.
Okay, so it will be Zoom. So if I keep that information I got from the last mailing, that should work.
Yeah, and there'll be a new agenda will be posted, so you can see the agenda online, like, probably on Thursday or Wednesday.
Yeah.
The agenda will have.
November 25th. Thank you. All right, thank you very much.
All right, thank you. Thank you for coming tonight.
Thank you.
Thank you.
All right, so we have one more thing on the agenda.
That would be
Okay, meeting schedule.
So with regards to the schedule, the last time we met on lights and generators, we discussed it.
And watch. Yeah, I hear them out there. Can you play the music every once in a while? Watching it. And if you open that all up.
Yeah, that's right, basically the fees with fine.
Same thing, Jeff. Right.
I think we're trying to make it
With it, or are you good to go?
Actually, good, I just, no, I
Doing
don't think you need to vote on that.
economically.
I guess tell there's.
Yeah.
So we're trying to make the
All right, next up is discuss.
the new area
law
to be
amendments.
as.
That pertains to. Oh, yeah, so zoning bylaw recodification. We're waiting to hear back from NAPC, inclusionary housing. And the, flood plains. Hi there.
Oh, Walter, yes.
Yeah. Well, okay.
That makes it.
Okay. All right, is there anybody, the recodification we're waiting on?
Yes, so yeah, Kristen, you know that one, you're quite familiar with that whole process. Yeah, I guess, I mean, I think for the most part, what I wrote here, and I apologize, it's a bit sort of lengthy, I am a writer. But I guess the crucial, I mean, I think most of it's pretty self-explanatory, you can read it and absorb it. I guess the crucial thing for now is, well, just so you know, but also, you know, ultimately for these 3 or 4, I guess hopefully 4 amendments, you know, typically I think it's the planning board that kind of proposes amendments, and of course eventually has a public hearing, and you know, all the warrant that's proposed by the planning board and so forth. But it doesn't have to, I mean, the select board and a few other entities can propose as well, and they can be proposed by, whatever they call it, from the public, I forget the term, petition. Petition or whatever it's called. But I guess, do you folks want to, you know, put forth, I mean, I think first, a few of these, I mean, for the battery energy storage, definitely there are lots of other people in town who want to push that one. So there's no doubt about that. For the other ones, does the planning board want to sort of push these ones for Springtown meeting? I mean, for recodification, I think that committee, that working group definitely wants that. But it's up to the planning board to kind of, to some extent, decide as well. I mean, I think the floodplain one is virtually ready, so that's not much of an issue, but the other two, the recodification and the inclusionary housing might be a little more up, sort of up for grabs.
Well, could we go ahead and put at least placeholders in?
Yeah,
Okay,
yeah,
because I think we could still continue to make progress there.
definitely, yeah.
So I had a discussion with the plan, with the zoning board, that's select board. They would like us to be the people behind battery storage.
Yeah,
They're looking for us.
yeah, that makes sense.
I think we requested a draft bylaw. Maybe.
Yeah, and so we've got that. It's one, oh, what was the name of the, I think the town is, it's basically based off of what the town of West Newbury passed at their town meeting recently, which has been more or less approved. I think I said you, did I submit? I think I said it's like approved by, the Attorney General issued like a 9-page letter, basically seeming to say that it's more or less passed its muster. So it seems like Amy's proposal, we use that as a template or model, and reuse most of their verbiage. And so I think that's, obviously where it says West Newbury, we'll change it to Duxbury, we may change a few other things, but for the most part, I think that's probably where we're gonna go with. Or at least that would be our starting point. Of course, it could change dramatically, in the next few months. But that would be the starting point, then I think that'll probably be the placeholder then. Yeah.
Well, then, so should we put that on an agenda and start talking about that?
Yeah, I think I'm gonna put, I'm definitely, unless you guys object, I'm definitely gonna have this on the agenda for November 24th, so we can have a more thorough discussion, it won't be at such a late hour. And yeah.
Will they have her draft bylaw there?
I think, sorry.
Basically West Newbury's,
Yeah, I think I'll just be changing West Newbury to Duxbury. And that'll probably be about it. I mean, unless
So it's
they
really
do
that,
more, yeah.
that's simple.
Well, we're probably gonna do more tweaks as we go on, is my guess. Like, we're still have a few months, there's a placeholder, but then it can still be. You can't change it completely because then you're sort of in violation, but you can make a lot of adjustments to these placeholders as it goes forward. And my guess is, we have to figure out, can we maybe restrict it from a few zones or, a few little tweaks we may want to put in. Bigger buffers or all kinds of stuff, maybe more regulations. But of course, we have to be careful because we can't just, apparently this is now within the Dover limit unless another court overrules the first court. And so we can't restrict it too much, basically.
And then I believe we have a meeting next year, so that sounds great, let's just get those on the agenda and just keep having meetings. Then, so we have a sense from MAPC when they're coming back for the inclusionary housing.
Yeah, so for that one, it seems like they're doing us a favor by looking at it again at all. Because the grant seems to have expired. So I don't want to press her too much on the timeline. I could tell her, please have it by December 1st, but I think I could also just put together a placeholder based on the original thing, and then like some of these comments and stuff, I could put together a placeholder for that as well, so. I'll try to prepare that by November 24th, so you guys have a chance to actually see these placeholders. That'll be good, I think.
That'd be great,
Yeah.
have them as attachments in our folder so we can. review
Yeah,
them.
yeah.
That would be great, and then, anything else with the zoning bylaws? I think you hit all four.
I think that's it.
Well, on the floodplain one, wasn't there still a little bit of? Read it very quickly, so I don't remember what the issue was.
Oh, yeah, so, yeah, because of the shutdown, the FEMA person,
Oh.
well, hopefully that's being resolved in the next few days, but she may have like a massive pile of emails to catch up on, but. To say the least, but, yeah, it's hard to know, but again, we can put that in as a placeholder, so that should be fine, I think we'll be waiting for. Hear back from FEMA and ECR,
That sounds good. All right, the next up, we have a joint meeting with the select board next week, and that is, we requested it a couple months ago. And that is to talk about our goals. And so really my goal was just to go back to them and say, these are our short-term or our long-term goals. I think we had something that was in a prior meeting. That line those, so that would be my goal, just sort of short and sweet, just make sure we're all in alignment, just check in with them, also let them know that we're planning on presenting 4 bylaws. And just highlight each one, so they're still in process. Like to have we planned a placeholder, we're still waiting on some feedback from some groups. Is there anything else, anyone else would like to bring up with them, do they know or don't know?
Well, yeah, I do, and that was where I'm going, and I thought that this discussion with joint meeting and the select board and the planning board was to not just look at the planning board's goals, but the whole comprehensive plan. Where are we? So is that not
Yes.
correct?
Yes, that is, that's one of the things, I think that it's, is that on the things, we definitely need to.
Yeah,
work on
because
this.
it's a good point that we ought to have our own ducks
Yes.
well ordered in terms of the action items we own. But I wanted to hopefully engage you, Matt, in conversation about this here and on this topic. That's where we stand with that, because it all goes back to that giant spreadsheet.
Yes, I've actually been working with that giant spreadsheet, and it certainly is colossal. But yeah, putting together like all these, I've created basically these things that show, it's kind of what the spreadsheet shows, but with a little more clarity, turning them to PDFs of like what the feedback we've gotten from the different committees and boards and departments. I think it was kind of in 2023 was when we did get that feedback, but most of the boards and departments did, provide feedback, kind of checking the box saying like, this task is in process, this one's complete, this one is no longer needed, or this one we haven't started, and so forth. And so I hope to have that ready, maybe within a few days, perhaps, depending on how busy we are. I'll try to get it ready certainly by next Monday.
Didn't Chris have this real long list of who was supposed to do what and what their status was?
Yeah, so that's pretty much what I'm talking about. Yeah, exactly. Yeah. And it is pretty massive, but I think once you guys see it all, it'll be quite helpful, I think. I mean, I'm sure as you see it, a lot of it will probably come back to you, but it'll be helpful to see it sort of as one big document. And then, you may want, you may want to then really think about kind of which ones you want to prioritize or how you want to speak to the select board to say, we'd love to prioritize these things. I mean, there's hundreds of items. So you probably can't really say, we want to accomplish all these, but at least just some of them, kind of, and see which ones are still applicable, which ones you really want to be your priorities. And also, of course, how much you can sort of push, and this may depend on the select board and Rainey, how much we can push other departments to say, hey, this is in the plan. I mean, obviously, we don't have any formal authority over them. But Rainey and the select board do, and so that's kind of where we can just say to them, hey, we think this is important. It's up to Rainey and the select board to kind of decide whether to tell another department like, hey, let's make this some priority.
I think that, thank you for mentioning that, Tag. That's pretty good.
All right, well, I mean, I think, in terms of this progress report idea, hopefully we'll be able to really have a solid understanding of where we are as a result of the meeting. The comprehensive plan is broken up into domains. And then the action items are associated with the domain and assigned to an owner, and then we focused on the owners. So I think we lost sight of the domain, so that might be sort of a high level summary, each of the domains, where are we? And that way you're not pointing the finger at anybody saying, oh, you didn't do your job, it's just general, where are we in the overall?
So I think I've only seen the term domain, at least in what I've looked at. I didn't read the whole, I haven't read the whole, Envision Duxbury document. But in kind of in the work I've done, I feel like I've only seen that phrase used once. So it doesn't seem that common.
We can call the areas.
Yeah, maybe.
It's basically the first number of the numbers.
Okay, yeah, maybe it's something else. But I think it is tricky because different things, as you say, different tasks are kind of assigned to different, like different action items and tasks are assigned to different offices and committees. But at the same time, there are these kind of areas and domains that often span multiple groups. And so, yeah, it's sort of simplistic to say, oh, you need to do it. Because sometimes it's both about those little details and tests, but also kind of about the big picture too. That's where it gets, I mean, I think that's what I can see the big picture, and maybe then all of you decide, all right, what do we want to try?
Matthew, anything else you wanted to mention aside from your report? Thank you so much for doing that. I think it's really helpful to refresh, it's organized, here's what's going on. Thank you. I know it's a lot of.
Oh, no, I mean, it's, in fact, I think it is a lot, right? I think it's actually helpful for me because it's put my mind into what I want or to what I want to communicate or the things that are relevant. So it's actually a really good exercise for me to kind of stay on top of these things and in preparation for the meeting. And yeah, I think, I mean, the last thing, of course, is the budget and the MVP 2.0, but those are pretty I mean, you can just see what I wrote. I don't think I need to add anything to that. You don't really need to do anything about that. Just be aware of them. And that's guessing everybody's probably ready to go.
I don't know, what do you think? Anybody have anything else?
Motion to adjourn.
Motion to close the public.
Second.
Oh, wait, did we close the public? I need the public hearing.
We continued all.
Okay.
And I think we.
The middle one, did we?
Oh, no, we did close we finished the one for.
ADU, did we close it?
Did we?
I don't think we did.
Yeah.
So maybe you should vote to close it. I mean, probably doesn't matter.
We have a motion to close the public hearing regarding the ADU, Surf Street. Second. All those, any discussion? All those in favor?
Aye.
Yeah.
Aye.
Thanks, motion carries. Thank you.
And now adjourn.
Oh, yes.
So moved.
Second.
Second.
All those in discussion, all those in favor? Any nays?